myself was surprised na yung palang ginawa, kung totoo man yun na ginawa, ano? Eh may connection dito.
Yes, sir.
Sa ICC case.
Yes.
If indeed it is true, the whole process of gathering evidence by the ICC investigator in The Hague becomes suspect insofar as the credibility, the veracity of whatever they gathered when the ICC investigators went to the Philippines for several
suspect
times.
in what part?
Wala silang alam dun. Wala silang kakilala dun. They do not know where to start insofar as their investigation is concerned. So, ibig sabihin, somebody there hosted them.
Yes.
Kung totoo man yung sa affidavit na yun, it appears na si Trillanes hosted them.
Breaking news, mga kaibigan! Ito po, nako, ito pong si Triniling, huli kabalbon. So, ayon po kay Attorney Delgra, mga kaibigan, ay talagang it becomes a suspect. Ito pong ICC, patungkol po ito sa $2 million na di umano'y bribery or yung sinasabi po nila, mga kaibigan, na suhol. Eh, alam naman natin po ang nakalagay po sa affidavit, mga kaibigan, na kumakalat ngayon sa social media na ito pong si Triniling ay nakikipag-ugnayan di umano sa ICC. So, mga kaibigan, matindi po itong ibinulgar ni Attorney Delgra. Dahil po, related po ito, guys, sa kaso ng ating dating Pangulong Duterte. Ngayon po sa ICC, mga kaibigan. At ito na nga, no? Itutuloy na po ang pangatlong hearing diyan po sa The Hague, Netherlands, ICC. Maya-maya po, mga 5:30 yata mag-umpisa, no? Abangan nyo po yan, mga kaibigan. Pero bago po yan, syempre, pag-usapan muna natin itong matinding pasabog po ni Attorney Delgra. At ito po, no? Meron po siyang magandang balita sa atin, mga kaibigan. Ayon po kay Attorney Delgra, guys, ay talagang ito pong mga charges versus Duterte, no, sa ICC ay mabasura or mababasura. So abangan po natin yan kung bakit po ito mababasura. Marami kasing factors no, na pwede po natin i-consider, mga kaibigan. Unang-una sa lahat po, itong matinding pasabog ng mga ex-Marines. So related din ito, guys, sa kumakalat na mga affidavit. Kasi ang balita ko dyan, itong mga affidavit po ay ipapadala daw sa ICC. Itong mga documents. At hindi lang yan, no? Hindi lang po sa ICC, mga kaibigan. Ayon din po sa source, itong mga documents doon, no, na hawak ngayon ni Attorney Levy, na pinapadala po ito hindi lang po sa ICC, pati po sa mga miyembro ng ICC, mga kaibigan. Kasi syempre, meron pa mga membro dyan, eh. Di ba? Meron pa pong mga iilang na mga bansa na under pa po sila ng ICC. Kasi karamihan po ngayon ay medyo nagwi-withdraw na po, no? Yung pinaka-last yata na nag-withdraw is Hungary, no? Kasi yung Africa po, buong state yata ng Africa, mga kaibigan, kung hindi ako nagkakamali po, ay unti-unti na po silang nagwi-withdraw sa ICC. So ngayon, pag ito pong documents or itong mga affidavit po na hawak ng mga Marines or mga ex-soldiers, pag nakarating po ito doon, ay sigurado po magwi-withdraw sila. Ibig sabihin po, talagang ang pinapagana po nitong gobyernong banga. Ano po ang kanyang sinasabi? Nito si dating Congressman Ace Barbers. Alam naman natin, guys, na isa po siya sa miyembro ng Tuwadcom. Oh, sabi daw niya, talagang hinahamon pa niya, itong si Attorney Levy tsaka itong mga ex-Marines. Ang hamon po niya, mga kaibigan, permahan daw. Oh, sabi pa niya, permahan nyo. Kung meron talaga kayong affidavit, kung meron talaga kayong sinumpaang salaysay, permahan nyo. Ganun pa siya, hinahamon pa, eh. Di ba? Ang galing no? Talagang hinahamon pa yung mga ex-marines Sabi niya notarize, permado at ihain sa ombudsman. Wow! Kailangan daw notarize at permahan para ihain daw sa ombudsman, mga kaibigan. Hindi ba niya alam? Hindi ba niya nakita na itong affidavit po ay kalat na po sa social media? At makikita niyo doon na permado po ng mga ex-marines itong mga salaysay nila. So, ewan ko lang, baka siguro hindi updated si dating congressman. Baka siguro natutulog sa pansitan. Ay, dati, Congressman Barbers, permado na po, sir. Oo, permado na. Notarized na rin, sir. Oo. Permado na po lahat, notarized na rin. At hindi lang yan. Meron po silang witnesses, no? May isang bishop at mga abogado. So, ibig sabihin, talagang pinanindigan nila, mga kaibigan, ang kanilang salaysay nitong mga ex-marines na haharap po ito, guys, sa mga hearing po. Ewan ko lang kung kailan po mag-uumpisa yung mga hearing na yan, pero ang pinaka-latest po idudulog mo ifa-file mo na ito sa ombudsman, no? Parang yan parang initial po, ombudsman muna. After ng ombudsman, kung wala talagang mangyayari, baka siguro doon pa lang gugulong itong sinasabi nating mga hearing. So, mga kaibigan, ito pong pag-uusapan natin ngayong hapon. Pasensya na po kayo kasi muna tayo, pag-uusapan muna natin itong mga bagay-bagay po, lalong-lalo na po itong nangyayari ngayon sa ICC. Dahil lahat po ng mga sinasabi po ng mga ex-marines ay konektado po ito, guys, sa kaso ng ating dating Pangulong Duterte. Kasi kung hindi naman po nakikipag-collaborate or hindi po nakikipag-ugnayan ang gobyerno sa ICC, hindi naman siya madadala doon. Kasi klarong-klaro po ang sinabi nila Unang-una, sinabi nila hindi sila makikipagtulungan, hindi sila makikipag-ugnayan sa ICC. Pero nabalitaan po natin sa mga ex-marines na ito palang si Trililing ay naga-underground, Meron pala siyang sariling lakad. Kaya po, mga kaibigan, lumutang po itong $2 million na di umano'y ibinayad po sa mga ICC investigators. Pero syempre, hindi pa naman kumpirmado yan, Kaya po, mga kaibigan, ito pong nangyayari ngayong hearing sa ICC ay talagang sampal po ito sa mga taong bayad. Lalong-lalo na po itong tinasabi nilang mga investigators ng ICC. Kasi po, kaya po sinabi po ito, guys, Kaya po sinabi ito ni Attorney Delgra po na talagang mababasura po, very positive po, guys, si Attorney Delgra na mababasura po itong kaso ni dating Pangulong Duterte sa ICC. Malamang sa malamang po ay makakauwi na po si Tatay Digong. Ewan ko lang po kung kailan po ang pinaka-final verdict, pero ang pinakahuling araw yata, kung hindi ako nagkakamali, ay bukas, Friday. Yun na yung pinakahuling hearing po sa confirmation of charges. Kasi syempre, after ng confirmation of charges, pag-aaralan nila yan, Magkakaroon pa sila ng mga dyan, siguro magdidebate pa sila dyan. Hanggang sa they will come up with the final results or yung sinasabi nilang the last verdict. Syempre, pag nagkaroon na po ng verdict, mga kaibigan, dalawa lang naman po yan, Dalawa lang naman po ang antayin natin dyan. Either it's confirmed or not confirmed. Pag confirmed po, mga kaibigan, ibig sabihin, tuloy-tuloy ang kaso. Tuloy-tuloy ang paglilitis. Yun na yung pinaka-grand of charges, Pero, pag sinabing not confirmed, yes! Uwi si Tatay Digong sa Pilipinas. Not guilty. Naku, kawawa itong mga... ewan ko lang kung anong gagawin dito sa mga hinayupak na to na talagang bayad. Siyempre, mga kaibigan, hindi po natin alam kung ano po mangyayari talaga dyan, Pero, kung hindi ako nagkakamali, meron yatang counter dyan, If ever lang, ito po, if ever lang po, example lang po ito, guys. Kunwari, ma-absuelto si Tatay Digong. Anong mangyayari po dinet? Ang alam ko, may counter dyan, Pwedeng may magbabayad na yata ng damages diyan pero hindi ako sure kasi nga hindi naman po ito ang yung tinatawag nilang na court of compensation, kasi may tinatawag na court of compensation meron ding hindi ang ICC po hindi po ito compensation guys, talagang court of po ito sa mga kriminal mga ganon. Pero pag hindi po nila napatunayan ng ating dating Pangulong Duterte ay may kasalanan, nako, ewan ko lang talaga, ayaw ko lang talaga magsalita guys. Pero ito, basahin muna natin itong si nagmamayabang, nagmamagaling dating Quadcom. Kaya po mga kaibigan, itong dating Quadcom po talagang ewan ko lang po kung ano pong nakain niya guys. Bakit bigla siya nagsalita? Okay, mamaya po guys babasahin po natin yung mga comment ninyo kasi medyo mahaba-haba po itong hearing. Tatlo po ito guys para lang po sa inyong kaalaman po. Tatlong session po ito Ang first session po is mga nasa 5 PM po. Ang pangalawang session yata is nasa mga 8 or mga 5, 6 or mga 7 Ang pinaka-last na session is nasa mga 9 PM. So aabutin po to ng hanggang alas 10 o hanggang 11 PM. Napakahaba po ito guys, kaya mag-ready lang po kayo dyan. Pero meron naman siyang break bawat session meron siyang break na 1 oras, kaya siya tumagal Kaya umaabot po siya ng 4 na oras, 5 oras po mga kaibigan. Kasi nga bawat guys, merong break. Hindi katulad nung hindi katulad nung mga ibang hearing po. Tuloy-tuloy wala na pong break. Kumbaga lunch working lunch po sila mga kaibigan. Pero dito po sa ICC guys ay talagang aabutin po siguro tayo mga 5 oras siguro to So anyway, tiyaga-tiyaga lang po tayo mga kaibigan para po sa ating dating Pangulong Duterte. Ito po, pag-usapan muna natin to guys. Ayan itong nagmamayabang. Talagang todo sila ngayon todo paliwanag po sila ngayon mga kaibigan, kasi alam nila guys na talagang delikado na po ang kanilang mga buhay. Nako, mukhang may maghihimas rehas talaga pero ewan ko lang yung sa yung sa flood control projects nga hanggang ngayon wala pa rin naghihimas rehas mga animal na yan hanggang ngayon wala pa rin big fish. Hoy, asan na yung mga big fish? Pero guys, sabi nga nila, eto na yung mga big fish. Eto na. Lalambatin na po sila. Bakit po lalambatin? Kasi ang dami. hindi kaya ng kawil-kawil lang Kailangan lambat ang gamitin. Kasi ang dami po nito guys. Okay. Basahin muna natin to Mamaya po yung mga comment ninyo Mag-comment lang po kayo dyan mga suki. Mag-comment lang po kayo, magtanong kayo mamaya para tuloy-tuloy po yung discussion natin. Lahat yan babasahin po natin. Alright, eto na po. Ang sabi po dito sa isang balita po mga kaibigan, ayon po kay dating congressman or dating miyembro ng Tuwadcom Tuwadcom affidavit na kwestiyon ni Barbers, notarized, permado at ihinain sa ombudsman. Nako, sapul ka dito. Sapul ka dito. Kasi po mga kaibigan, ito kasi ang sinabi niya guys basahin lang po natin Ang sabi niya, nauna ng hinamon ni Barbers ang 18 or 18 na sundalo na pirmahan daw sabi niya pirmahan at ipanotaryo ang kanilang affidavit kaugnay ng aligasyon ng pagde-deliver ng mga male-maletang at bag na pera sa ilang mambabatas. Anya, if you want your compassions are saying is true, then have them sign their affidavit and have it notarized para hindi magbukang script ng isang drama skit sa barangay. Pirmahan nyo. Sabi niya, pirmahan nyo. Kaso lang mga kaibigan, napahiya po siya guys. Napahiya po siya. Kasi hindi niya akalain na itong lahat na lumabas na affidavit po ay pirmado na, notarized na, at meron pong witness. Ayan, sampal sa mukha mo. Ang yabang kasi. Bago kasi kayo magsalita, manood muna kayo kay Foodinet para malaman nyo kung talagang may permado ba yan. Ayan ayan, pakita natin. Ayan Yan po nakikita nyo guys sa litrato mga kaibigan. Yan po yung pirma. Siyempre, tinanggal lang po yung mga pangalan, no? Para hindi po tinanggal lang po yung mga pirma guys para hindi magaya, no? Kasi siyempre, alam naman natin ngayon, marami po ngayon mga masasamang elemento, gumagamit po ng mga AI, gumagamit po ng mga apps na pwedeng gayahin po yung mga pirma, no? So, kaya po nakatakip ito. Pero kita nyo naman, 18 yan, ha? 18. Lahat yan, pumirma, ha? Congressman, ha? Baka sabihin mo, hindi pirmado. Oh, kuryente ka tuloy. Kaya po mga kaibigan, ito pong mga pulpul na mga dating mga miyembro ng TUWADCOM ay unti-unti na po silang lumalabas at nagsasalita. Kung babasahin po natin dito, mula sa pagiging scrap of paper, sabi pa niya, oh, mula sa pagiging scrap of paper daw, na kinestyon ng dating mambabatas, ang affidavit na tinaguriang Brave 18 ay ngayon pirmado na, notaryado na at formal nang inihain sa Office of the Ombudsman. Okay, klaruhin ko lang guys ha. Ngayong araw po, formal na po itong naihain sa Office of the Ombudsman. Pirmado na, notarized na. So ibig sabihin, bahala na po ang Ombudsman guys kung anong gagawin niya doon sa mga documents. Kung papanigan ba niya, kung imbestigahan ba niya itong mga to, yung mga individual na nakalagay, or ibabasura lang niya. Pero at least mga kaibigan, sumunod po sa due process si Attorney Levy Baligod at saka itong mga ex-Marines. At least, di ba, sumunod sila sa batas. Hindi katulad ng iba dyan ay mahilig magbendalo. Di ba? Yung iba dyan mahilig magbendalo eh. Oh. Nauna ng hinamon ni Robert H. Barbers ang 18 dating sundalo na pirmahan at ipanotaryo ang kaninang affidavit kaugnay ng aligasyon ng pagdi-deliver ng maletang mga bag at pera sa ilang mambabatas. If you want your compassions are saying is true, then have them sign their affidavit and have it notarized para hindi magbukang script ng isang drama skit sa barangay. Pirmahan nyo. Sabi po. Dagdag pa niya, an unsigned affidavit is just a scrap of paper. Ibig sabihin guys, ang affidavit daw na walang pirma ay isa lamang piraso ng papel. Sa pinakahuling development, ipinakita na sa publiko ang dokumento na may mga pirma na mga affiant at mga notarial jurat, no? At may mga petsang February 23, 2026 sa Las Piñas City. Ayon sa kampo ng abogado ng grupo na si Levy Baligod, naihain na rin ng dokumento sa ombudsman. So nasa ombudsman na po. We are here in the office of the Ombudsman because this office has a primary jurisdiction to investigate government officials allegedly involved in corruption. Sabi po ni Attorney Baligod. Narito kami sa office of the Ombudsman dahil ito may pangunahing jurisdiction upang imbestigahan ang mga opisyal ng gobyerno na umano'y sangkot sa katiwalian. Ayon pa sa kanya, we are here to present a prima facie proof that an offense has been committed. No? Ang ibig sabihin po ng prima facie po mga kaibigan, first impression, no? These offenses include graft and violations of RA 6713. Tumanggap sila ng milyon-milyon ng pera, hindi po sila naipakita sa kanilang mga salin. So ibig sabihin guys, RA 6713 isa po sa mga kaso ng graft. Nako, grabe, graft po ito guys. No bail. Narito kami upang magharap ng prima facie proof na may nagawang paglabag. Kabilang dito ang graft at paglabag ng RA 6713. Tumanggap rin ng milyon-milyong piraso, ngunit hindi ito maipakita sa kanilang salin. Ang pinakahuling hakbang na ito ay malinaw na sasagot sa hamon ni Barbers na gawing formal ang legal ang affidavit. Ngayong pirmado, notaryado at naisumite na sa ombudsman, ang susunod na yugto ng isyu ay nasa kamay na ng mga nasabing tanggapan. Kung magsasagawa ito ng paunang investigasyon at kung may sapat na batayan upang maghain ng kaso, sa puntong ito, mula sa pagiging dokumentong kinekstyon ang affidavit at pumasok na sa opisyal na proseso at inaasahan ang legal na investigasyon, magbibigay linaw kung alin ang may sapat na ebidensya at alin ang mananatiling aligasyon. Ayan po mga kaibigan ang ating pong update po dito kay dating TUWADCOM member na si dating Congressman Barbers. Oh, ayan ha, klarong-klaro po yan ha. Baka sabihin na naman niya, hindi permado, tsaka walang notarize. Hindi notarize. At least ha, pinakita talaga natin guys, at napaliwanag din po dito sa balita, na talagang ito po ay nasa batas, nasa legal na proseso, due process. 'Di ba? Sabi pa nga ni Attorney Baligod kanina, 'di ba? Meron pang mga abogado at mga bishop, no? Na yun po yung parang yun po yung parang mga witness no? Kasi syempre kailangan mo ng witness diyan Kasi manunumpa ka diyan at syempre mga kaibigan, papatunayan mo yung mga salaysay mo para po mabigyan po ito ng notarize. So ngayon, dahil po ito'y nakahain na po sa ombudsman mga kaibigan, aabangan na lang po natin ang mga susunod na kabanata. For the meantime, pakinggan muna natin guys, itong si Attorney Delgra sa kanyang pahayag po patungkol po dito. Itong kay Trililing, nako, ano kayang gagawin kay Trililing mga kaibigan? Ha? Ano kayang gagawin kay Trililing? Grabe naman talaga. Ito pa, bago po natin pakinggan si Attorney Delgra guys, isingit ko muna to no? Kasi kailangan po natin itong malaman mga kaibigan, kasi kanina po naging topic natin itong si teacher. Sinabi po natin kanina guys na bigla po siyang nawala, di ba? Ito po ang kanyang paliwanag no, kung bakit po bigla siyang nawala at wala na po yung page niya. O alamin natin kung ano po ang kanyang paliwanag po mga kaibigan, para malaman din natin guys kung ano ba talagang nangyari sa kanya. Ha? Ito po no, pakinggan lang basahin lang po natin dito. Ito po mga kaibigan no. Ito po ang pahayag ni teacher. Mahirap yung pambabash para sa aking mga anak. Talagang nakatanggap sila ng mga mensaheng may galit. Hindi ko napagtanto kung gaano kalupit ang mga mensahe hanggang sa ako na mismo ang nagbasa. At hindi ko nga kayang ilarawan sa inyo. Yan, sabi po niya doon sa Billionaire News. Kasi in-interview po siya. Nangangailangan iyon ng maraming pagpapaliwanag at para sa isa sa kanila, kinakailangan talaga namin ng professional na tulong. So ang dinahilan po niya mga kaibigan kung bakit po biglang nawala ang kanyang page dahil po sa kanyang mga anak, no? Patuloy ang usap-usapan online matapos mapansin ang mga netizens na hindi na ma-access ang official Facebook page ni Stella Kimbo. Hanggang ngayon, wala pang opisyal na kumpirmasyon mula sa kanyang kampo kung voluntaryo ba itong dina-activate o may ibang dahilan sa likod ng pagkawala ng page. Ang development na ito ay lumutang kasabay ng muling pag-init ng diskusyon sa social media. Kaugnay ng mga aligasyon na tinaguriang Brave 18, ang 18 dating sundalo at Marines na naglabas ng joint affidavit tungkol sa umano'y pagdadala ng malalaking halaga ng maletang pera sa ilang opisyal at personalidad na kinabibilangan din ni Stella. Kasabay ng pagkawala ng kanyang social media page, muling ibinahagi online ang bahagi ng isang panayam kay Kimbo. Isang taon na ang nakalipas sa Billionaire News Channel kung saan siya ay in-interview ni Karen Jimeno. Sa nasabing panayam, inilahad ni Kimbo kung paano nakaapekto sa kanyang pamilya, lalo na ang kanyang mga anak, ang mga aligasyon at isyong binabato sa kanya. Stella Kimbo, what was pretty tough on my kids. Sabi niya guys, that was pretty tough on my kids. They would really get hate messages and I didn't realize how hateful the messages were until I started reading them and I cannot even describe them to you, Karen. Sabi niya ganun. Kung sa Tagalog pa, sabi niya, mahirap iyon para sa aking mga anak. Talagang nakakatanggap sila ng mga mensaheng may galit. Hindi ko napagtanto kung gaano kalupit ang mga mensahe hanggang sa ako na mismo ang nagbasa at hindi ko na nga kayang ilarawan sa iyo, Karen. Yan. Reporter Karen Jimeno, yeah, that must be hard for a mom, not because of yourself, but you're worried about your children and how did you handle that? Kung paano daw niya hinandle yun, no? Sabi niya, look, took a lot of explaining and one of them were actually needed professional help. So nangangailangan daw iyon ng maraming pagpapaliwanag at para sa isa sa kanila, kailangan talaga namin ng professional na tulong. Sa panayan na iyon, malinaw na ibinahagi ni Kimbo ang emosyonal na epekto ng mga aligasyon sa kanyang pamilya, particular sa kanyang mga anak na umuwi nakakatanggap ng hate messages online. Ngayon, sa gitna ng panibagong diskusyon at sa pagkawala ng kanyang Facebook page, nabubuhay ang usapin kung dulot ba ito ng panibagong pampublikong kontrobersya sa pribadong buhay ni Stella. Sa kasalukuyan, wala pang inilalabas na opisyal na pahayag si Kimbo kaugnay ng mga isyong ito. Ito lang po, ang tawag dyan guys, lesson learned. Diba? Hindi kasi kayo natututo. Ang problema kasi sa inyo, hindi kasi kayo nagpapaliwanag. Diba? Sinabi na po ng mga professional yan eh. Para hindi po kayo maipit sa mga ganyang usapin, lalo na po sa corruption, kailangan magpaliwanag kayo. Diba? Kailangan lumabas kayo. Diba? Kailangan magpaliwanag at kailangan lumabas kayo. Ang problema kasi dyan sa iba, bigla-bigla na lang pong naglalaho. Bigla-bigla na lang pong nawawala at hindi na po mahagilap. Yung iba nga, nasa abroad na eh. Diba? Hindi. Sinong may kasalanan? Kayo din po ang may kasalanan. Kasi sinabi na nga yan eh, na if you're not going to if you're not going to explain or if you're not going to be out in the open, it is going to be your narrative. Ibig sabihin guys, pag hindi ka daw nagsalita at hindi ka lumabas sa publiko at hindi ka nag-go public, yung sasabihin po ay magiging naratibo mo yun. So kailangan i-explain mo, kailangan ipaliwanag nyo. Ang problema kasi hindi kayo nagpapaliwanag. Kaya po ang nangyari guys, marami po nagsasabi na pagtahimik, hindi nagsasalita, anong ibig sabihin? Yes, guilty. O, di ba? Kasi po, may tinatago kasi kayo. O, di ba? O, karma comes. Ibig sabihin, syempre, unti-unti din siguro silang nakakarma. Kasi po mga kaibigan, kahit saan po natin tinang anggulo, meron naman talagang dapat managot dito. Ang problema, sa sobrang dami po guys, sabi nga nila, sindikato na po ito eh. Kung tutuusin, sindikato na po ito guys. Hindi na po ito ordinaryo na kaso. Sabi nga, ang gobyerno po ng Pilipinas ay napapalibutan po ng mga oligarko at mga sindikato. Nagsasabuatan po sila mga kaibigan. Kaya paano po natin masusugpo ang corruption kung lahat po sila ay involved? Iyon lang, di ba? Yan ang problema. So maya-maya po, mag-uumpisa na po tayo guys. Maya na lang po natin pakikinggan si Attorney Delgra kasi maganda po ang kanyang good news. Makakalabas po at makakalabas po no or mananalo po ang ating Pangulong Duterte dito sa kanyang charges no sa ICC po. Positive, very positive po ang sinabi po ni Attorney Delgra guys. Kasi po, based po ito sa mga nangyayari ngayon. Itong mga lumalabas na itong mga investigador ng ICC ay may kaugnayan po dito kay Trililing. Nako, ito po no, ayusin lang po natin mga kaibigan kasi mukhang mag-uumpisa na po tayo. Wait lang ano lang po kayo dyan, mag-like and subscribe lang po kayo sa channel namin dahil pag nag-like and subscribe po kayo ay masaya na po si Foodinet. Yan lang po ang kaligayahan namin kaya maraming salamat. Ito po guys, no, ayusin lang po natin wait lang po andyan lang po kayo para maganda po ang ating mamaya. Kasi usually talaga mga kaibigan, mag-uumpisa po yan mga 5:30 po, no? Pero minsan late, minsan maaga. So antayin na lang po natin ng konti. Ayan, wait lang po mag-ano lang po tayo dito. Ito po, ipakita ko lang muna sa inyo guys para meron po kayong kung ano po masasabi nyo dito. Ayun oh. Pakibasa po sa inyong screen mga kaibigan habang nag-aantay po tayo guys. Pag-usapan muna natin tong si Santong Kabayo. Santong Kabayo, banal na aso, baliktad pala, banal na aso, santong kabayo. Okay, mga kaibigan, ito po. Oh, meron pong ano ba tawag dito? Sermon? Sabi po ni Boy Dila, huwag kang sasaksi ng walang katotohanan laban sa iyong kapwa. No. Makikita daw ito mga kaibigan sa Exodus chapter 20 to 16. Oh, di ba? Meron pa siyang Bible verse, ha? Itong si Atras Abante, ha? Talagang nangaral pa po itong si pastor, mga kaibigan. Oh. Makinig kayo, Attorney Baligod at mga ex-Marines. Ayon po dito kay pastor. Ang sabi po dito mga kaibigan, ito ang talata na ibinahagi ng mariing pagtanggi ni Manila 6th District Representative at Pastor Benny Abante sa aligasyong tumanggap umano siya ng maletang may lamang pera. Kasunod ng mga revelasyon ng 18 dating sundalo tungkol sa umano'y pagdi-deliver ng cash sa ilang personalidad na kinabibilangan umano niya. Sabi niya, completely false, baseless at malicious. O malicious daw mga kaibigan. Sa kanyang opisyal na pahayag, iginiit ni Abante na walang katotohanan ang akusasyon laban sa kanya. The accusation that I accepted suitcases of cash is completely false, baseless, and malicious. Categorically deny it. I categorically deny it. So mga kaibigan, wala daw katotohanan ang lahat, no? Ang lahat po na sinasabi po mga kaibigan ng mga ex-Marines. At nagbigay pa siya ng Bible verse. Paghilom, oy, Boy Dila. Ito naman kasi si Boy Dila eh. Ha? Oy, Boy Dila, paghilom daw, paghilom. Ha? Talaga bang pastor yan? Ha? Totoo ba talagang pastor to mga kaibigan? Parang hindi naman pastor. Ha? Opo, Bible verse ni pastor. Ngunit sabi ng Diyos, tumatawag sa kanya ay tunay na lingkod niya. May mga bulaang tulad ni mga bulaang pastor. Baka bulaang pastor, no? O kaya kulto. Ay, nako, Diyos mio, Marimar. So, mga kaibigan, abang-abang lang po tayo, guys. Mga ilang mga ilang minuto po ay mag-uumpisa na po ang confirmation of charges. Kung hindi po ako nagkakamali, mga kaibigan, mukhang si Attorney Nicholas Kaufman na po ang magsasalita, guys, kasi the last time lahat po ay puro prosecutors po, no? Binasa po nila yung mga confirmation of charges. Sana po this time, guys, pagbigyan naman nila ang defense. Sana po magsalita na po si Attorney Nicholas Kaufman. At ang pinakahihintay po ng lahat, mga kaibigan, ay sasabihin po or kumbaga guys, i-confirm ni Attorney Nicholas Kaufman sa harapan po ng judges ng ICC na wala pong jurisdiction ng ICC over sa Pilipinas. Yan po ang aantayin natin, guys, kung sasabihin ba po. Kung yan po ay sasabihin ni Attorney Nicholas Kaufman mamaya, guys, sa confirmation of charges ng ating Pangulong Duterte. Kasi alam naman natin, mga kaibigan, na andun po yung mga magigiting natin na mga magagaling na abogado, no? Andyan po sila Attorney Panelo, Attorney Delgra, Attorney Bello, sila si Medjel Dea, no? Marami po sila doon. At alam naman natin, guys, na nagkakaroon po sila ng mga meeting, malamang sa malamang. So, expected na po natin yan na tinuturuan po nila or binibigyan po nila ng mga insights etong si Attorney Nicholas Kaufman, no? Siyempre, tutulungan po nila yan kasi kaya nga sila andun eh, para magkakaroon po ng collab. So, kaya karamihan ngayon nag-aabang sa sasabihin po kung ano po ang magiging defense ni Attorney Nicholas Kaufman sa mga sinasabi nung nakaraang araw. Dahil hindi po siya nagsasalita, di ba? Kasi ganun yan eh. Palitan po yan eh. So ngayon mga kaibigan, I think high time na po para malaman po at isiwalat po ito ni Attorney Nicholas Kaufman na wala pong jurisdiction ang ICC sa Pilipinas. Sana sabihin niya sa harap, no? Sa harap ng mga judges. Iano niya, isampal niya. At saka sana sabihin po ni Attorney Nicholas Kaufman, guys, yung ginawa po ng mga investigador ng ICC. Nako, isusumbong niya, no? Kumbaga, isumbong niya, no? Sabihin niya doon. Sabihin niya doon sa mga judges na ginawa nitong mga investigador ng ICC. Kung paano po sila nakikipag-ugnayan dito kay Triniling at sa gobyerno po. Sabihin niya lahat. Total, ando na yung affidavit eh. Di ba? Hindi naman yan marites. Kasi meron naman talagang sinumbaang salaysay. Oh. Sabihin niya lahat ng lahat, no? I-reveal niya lahat ng mga sinabi ng mga retired, mga ex-marines. At syempre guys, dito kay Attorney Baligod, isumbong niya si Triniling. Sabihin niya ang pangalan ni Triniling para kabahan. Oh, sana po sabihin po 'yan ni Attorney Nicholas Kaufman kasi related po ito guys sa kaso ng ating dating Pangulong Duterte. Kasi syempre mga kaibigan, kung hindi naman niya nabayaran yung mga investigador na 'yan, hindi naman ito mangyayari. 'Di ba? Kaya nga nakakapagtaka eh. Talagang sila po ang nag-host. Sabi nga ni Attorney Delgra, kung walang nag-host diyan, wala po sila dito. Kaya sila nandito kasi may nag-host. Ang tanong, sino ang nag-host? Kaya po, lumabas ang pangalan ni Triniling. At syempre mga kaibigan, hindi lang po si Triniling, pati po ang administrasyong bangag. Kasabwat po dyan. May connivance po, mga kaibigan. So, sana po, hindi naman tayo nag-expect, no? At hindi naman natin pwedeng pangunahan. Pero ang sa akin lang po mga kaibigan, masaya na po ako guys kung sasabihin po ni Attorney Nicholas Kaufman na walang jurisdiction ang ICC over sa Pilipinas. Talagang papalakpak po ako. Kasi sinabi na po ni Sinabi na po ni Attorney Panelo yan sa kanyang ambush interview doon sa ICC, 'di ba? Tinanong nga siya. Ang gusto niyang marinig galing po kay Attorney Nicholas Kaufman, nasasabihin niya sa harap ng mga ICC judges. 'Di ba? Tapangan niya yung sarili niya, sasabihin niya, wala kayong jurisdiction. 'Di ba? Maganda yung ganun eh. No? Sana po. Once again, hindi naman po tayo mag-i-expect, no? Basta po, ang gusto lang po natin guys, matapos na po itong confirmation of charges, para po lahat po tayo ay mabigyan na po ng karampatang resulta at syempre yung pinakahuling verdict po kung ano po ang kanilang masasabi o kung ano po ang kanilang magiging hatol, no? Sa ating dating Pangulong Duterte. Syempre guys, tuloy-tuloy pa rin po ang mga prayers ninyo. 'Di ba? Araw-araw po prayers. Kasi alam naman natin guys, hindi naman tayo pababayaan eh, no? Sabi po ni La Bonita Maldita, wag tularan ang bulaang Pastor Abante, maleta. Yes! La Bonita Maldita ng LA. Ayan, okay. Medyo wala pa, hindi pa pala nag-umpisa. Kala ko nag-umpisa na. Wala pa. Konti-konti pa po mga kaibigan. Baka nag-prepare na po sila, no? Kasi minsan talaga guys, nalilate eh. Usually po, talagang matagal po nag-umpisa. Kaya po mga kaibigan, antay-antay lang po tayo ng konti, no? Pag naputol po yung live natin, magla-live tayo uli, ha? Ganun lang po gagawin natin guys. Kasi minsan hindi po natin maiiwasan, bigla-bigla po napuputol ang live, no? Kasi minsan, ginugurgur tayo. Basta pag naputol po, gawa kaagad tayo ng panibagong live. Kaya antay lang po kayo dyan. Alright? So, tuloy-tuloy po tayo mga kaibigan. Mag-likes muna tayo at mag-subscribe habang nag-aantay po tayo sa confirmation of charges po sa ating dating Pangulong Duterte. Live po tayo mga kaibigan, mga suki. Pasok na po kayo. Dahil mga ilang minutes po ay mag-uumpisa na Shoutout muna tayo, no? Hernando Vidal, ayan. Shoutout kay Marites Macumao. Mahirap nga yan, Teacher Kimbo, pero you have to face kasi tumanggap ka talaga. Talaga naman itong si teacher, oh. Alam nyo guys, nagrereklamo pa sila, no? Itong mga mambabatas po na nakatanggap ng bilyon-bilyong pera, maletang pera, nagrereklamo pa sila. 'Di ba? Nagrereklamo sila na binabash sila. Nagrereklamo sila na binubuli yung mga anak nila sa school. Sino may kasalanan? Tanong ko lang sa inyo guys, sino may kasalanan? 'Di ba? Kayo din naman may kasalanan yan eh. 'Di ba? Tama ba mga kaibigan ang sinabi ni Pudinet? Leticia Alcala, I Abante, with what you have done and who are you have no right to use God's word to suit your evil purpose. Yes, I agree. Leticia Alcala. Kumbaga, yung iba kasi dyan, nagaan yung tupa, no? 'Di ba? May ganun eh. Ganun yung mga karamihan po sa mga pastor, eh, no? Hindi naman lahat, no? Pero karamihan po sa mga pastor, guys, nagaan nyo silang tupa. Pero sa loob pala nun ay mga mababangis na mga lobo. 'Di ba? Akala mo lang mga tupa, eh, no? Akala mo hindi makabasag pinggan, eh. Pero sa loob pala nun ay mga mababangis na mga lobo. Yes, Mercedes Miras, kung ano ang tinanim, siya din aanihin. Yes. Sabi ni Hernando Vidal, yes, pabiktim pa, animil. Oo nga, ang dami pabiktim ngayon, no? Tama po kayo, Hernando Vidal, ang daming pabiktim. Sabi ni Vitz, keep holding on, Tatay Digong, we are praying for you. Yan, si OK Nald Hardy, kanina pa nag-umpisa. Wait lang po tayo guys. Tingnan po natin kung baka nag-umpisa na po. Check lang po natin guys ha. Wala pa, hindi pa nag-umpisa. Check lang po natin dito. Bakit late sila ngayon? Late yata sila ngayon, no? Kasi dapat nag-umpisa na eh. Anong oras na, oh? 5:12 na ba? 5:12 na po. Medyo late po sila ngayon, guys. Oo, ginamit niya ang pagkapastor niya, Hernando Vidal. Sabi naman ni Jerome Rebecca, murag mga uwak sila kahit may bit-bit. Magsabi pang, wow, wow, wow. Parang mga uwak. Ayan, Jose Kia, ang demonyo ng anyong pastor. Si Menchi Hison, baka ginamit ni Sister Pondo nung tumakbo siyang mayor sa Marikina. Oo, malamang ginamit talaga yung mga pondo na yan. Opo, may ebidensya po, Omar Lapina, yung yung mountain bike. Huling-huli yung mountain bike eh. 'Di ba? Si Tessa James, Pastor Abante, ano ka? Ayan. Hernando Vidal, late, wala pang maleta. Wala pang maleta. Oo, wag sana isabotahe ang signal, no? Kasi palagi na lang sinasabotahe yung signal eh. Katulad ngayon, hindi pa nag-uumpisa. Bakit kaya hindi pa nag-uumpisa? Baka siguro nag-umpisa na, no? Hindi lang natin alam. Baka ayaw nilang ipanood sa atin, guys, yung hearing ngayon. Baka matindi po ang sasabihin ni Attorney Nicholas Kaufman. Ha? Baka takot po sila kung ano sasabihin ni Nicholas Kaufman. Kaya ayaw nila ipakita sa atin kasi Ang nakalagay po sa ano nila, sa kanilang waiting is 4:55 PM. Anong oras na? 5:14 na PM na. Medyo sobrang late na po sila, guys, no? Filipino time din pala tong ICC. Ayan, tuloy-tuloy lang po tayo, guys, ha. Tingnan natin sa mga ibang wala pa nga kahit sa ibang wala pa eh. Opo, bigla po siya nagkaroon ng artista van. Oo, siya yun. Maraming nangagulat eh. Kasi dati po talaga, guys, sabi nila, nagta-tricycle lang daw yan. Oo. Talagang, minsan nagta-taxi lang, minsan nag-jeep. Talagang sobrang hirap po talaga ng buhay niya. Hindi naman super hirap, no? Meron din naman silang kinakain, no? Hindi po sila sobrang hirap. Siguro mga well off, parang sabihin natin well off, no? May kaya sa buhay. Pero nung pumasok po yan sa Kongreso, guys, nagulat ang lahat. Bigla pong gumanda ang kanyang mga nagkakaroon po siya ng mga mamahaling mga bags. Nagkaroon po siya ng artista van. At lumalaki na po ang kanyang mga sasakyan. Dati, sabi ko nga sa inyo, naka-tricycle lang eh. Pero ngayon, bigla-bigla na lang pong gumaganda ang kanyang mga sasakyan. Ano po ibig sabihin yan? Di ba? Paano niya nabili yung mga yan? Paano niya na-purchase yung mga yan? Sobrang hirap niya dati. Nanalo siya sa loto? Pera lang kung nanalo siya sa loto, one time, big time. Pwede. Di ba? Kaya po, napaka-questionable po ng kanyang mga pinapakitang gamit. Ang problema din kasi dyan, kasalanan din niya eh. Kasi siya po mismo, pinopost niya sa Facebook yung mga mamahalin niyang gamit. Yung mga relo, mga bags, mga signature talaga ng mga branded. So, kasalanan din niya. Ayun. Nung nalaman po, nakatsinelas lang daw yan. Oo, La Bonita. Nakita nga yung paa niya eh. Yung paa niya parang paa ng Talagang asin nakatsinelas, naka-tricycle. Oo. Pero nung pumasok sa Congress, bigla na lang, ayun na, biglang yumaman. Biglang nagbago ang itsura. So, doon pa lang mga kaibigan, talagang hindi mo po masisisi ang mga netizens. Kasi sila mismo po ay pinapakita nila yung mga kayamanan nila. Di ba? Pero nung nagkaroon na po, guys, nung nagkaroon na po ng mga hearing na mga skandal, yun na po, pinagbubura na po nila. Pinagtatanggal na po yung mga photos, lahat ng kanilang mga Facebook para hindi po sila makita ng mga tao. Tapos, hindi lang po siya, marami pong kaya nauso yung mga nepo babies eh. Hanggang sa nakita po lahat yung mga pinagbibili na ng mga luxury cars, mga mansyon, ng mga bahay, mga travel po sa ibang bansa, kung ano-ano na lang, no? Kung ano-anong bansa, sa France, punta sila ng UK, punta sila ng Amerika, Australia. Nililibot po nila ang buong mundo, mga kaibigan, para lang magbakasyon. Siyempre, sa sobra ba namang dami nilang pera eh. Di ba? Sa sobrang dami nilang pera, kahit saan pa sila magpunta. Baka nga yung mga yan ay may mga bahay na po sa iba-ibang lugar ng Pilipinas, sa iba-ibang lugar ng mundo. Diba? May mga mansion na siguro yan, may mga kondo. Kaya sabi nga nila, guys, pag nagkaroon po ng problema ang Pilipinas, iiwan po tayo ng mga yan. Tayo po ang sasalo ng bala. Sila, fly! Bye-bye! Kasi po, mga mayayaman. Diba? So, mga kaibigan, tuloy-tuloy lang po tayo, guys. Ano po nangyari? Hindi pa rin nag-umpisa. Ano nang nangyari? Lumampas na po sila sa kanilang waiting. Almost 30 minutes na po. Hindi pa rin po nag-uumpisa, mga kaibigan, kasi ang nakalagay po sa kanilang sa kanilang ano no, sa kanilang standby is 4:55 PM mag-uumpisa. Pero bakit hindi pa rin nag-uumpisa? Anong nangyari? Anong aberya? Baka hindi po, baka ayaw nilang ipanood sa atin kasi iba yung sasabihin ni Nicholas Kaufman. baka may sasabihin si Nicholas Kaufman, baka tama nga siguro ako, sasabihin niya, wala kayong jurisdiction. Kasi yun talaga yung pinakaabangan dyan eh. Yung babanggitin po ni Nicholas Kaufman, guys, na wala kayong jurisdiction. Di ba? Tingnan natin kung anong magiging reaction ng mga judges. Pastor Maleta. Oh, tama yan, Pastor Maleta. Yan, tama yan. Magandang ano yan, magandang pangalan yan, Pastor Maleta. Oh, yan po, mga kaibigan, no? So, mag-isang oras na po tayo. Wala pa rin. Sabi ni Inando Vidal, bro, ayaw kong tumira sa Forbes, baka akalain magnanakaw din ako. Yun lang. Lilian de los Santos, baka po binabasa pa yung script ng mga biktima ko noon sa drug on war, kaya late para di magkamali pagsagot. Lalo na po yung mga matanda at sinungaling. Bahala sila sa buhay nila. Uuwi na lang si Tatay Digong. Ayan. Jerome Rebecca, Fudinet, bukas pa daw si Attorney Nicholas Kaufman. Bukas pa ba si Nicholas Kaufman? Giatay. Akala ko ngayon eh. Bakit bukas pa? Wala na bukas eh. Bukas huli na yun eh. Dapat ngayon siya magsalita si Nicholas Kaufman, hindi bukas. Bihira naman oh. Bukas tapos na yun eh. Baka siguro ang magsasalita ngayon yung mga yung mga biktima. Oo, mga biktima po kasi meron pong pinakita, guys. 3 sila, mga matatanda, mga biktima. Oo. Totoo ba yung nakita ko sa Facebook? May nakita kasi akong Facebook, guys, na 3 sila, mga matatanda. Oo, pero ewan ko kung fake news ba yung may dala daw silang, may hawak daw sila ng mga mamahaling handbag. Mga signature, mga branded daw. Sila ba yun? Ewan ko lang kung totoo po yun ha. Hindi po natin sinabing confirm ha. Pero ang gagara po ng kanilang mga handbags. California girl, hello. Idol Floyd Sakay is watching your live para kay Abante and Stella. Karma is real and praying for Tatay Digong. Thank you very much, California girl. Oo, naka-LV daw. Totoo ba yun? Naka-LV daw, guys? Or baka lang? Baka siguro edited lang siguro yun. Baka AI naman. Kasi yung 3 daw, mga daw yun, mga biktima daw, mga mothers yata yun. Tapos nagpa-picture sila, 3 sila. Meron daw silang hawak ng mga LV. Ang tataray, naka-LV ha. Ang laki ng pera ninyo ha. Nakita ko talaga nakita ko talaga doon sa Facebook. Pero syempre, hindi naman tayo hindi naman tayo basta-basta naniniwala po hanggat wala pong confirmation. Natatawa lang ako, guys, kasi nga kung totoo po yun, mga kaibigan, nakabili ka agad sila ng LV sa sa Netherlands. Ang mahal-mahal kaya ng LV. Di ba? Magkano kayang LV sa ibang bansa? Lalo na sa France, ang mahal ng LV. At magkano kaya, syempre, alam niyo, wag na sila mag-deny. Kasi, imposible namang hindi binayaran yung mga yan. Di ba? Pupunta ba yan ng dahig kung hindi binayaran? Syempre, binayaran yung mga yan. No? Hindi lang nila, may yan, may konting yan. Oo. Para, pocket money siguro, o mag-shopping muna kayo sa France. O, mag-shopping kayo sa France, punta kayo sa LV. Ay, di ba? O, oy, may LV sa France, di ba? Napakamahal. LV sa France. Yung kung saan yung mga artista natin palagi pupunta doon. Doon bumibili si Hart. Alam nyo ba, guys, yung LV sa France, doon bumibili sa Hart. At suki si Hart doon. Sinong Hart yan, sir? Ewan ko, sinong Hart? Ang dami namang Hart, Okay, nako, ano na nangyari? Ba't wala? Pambihira naman, oh. Nako, mukhang may aberya po ito, guys. Mukhang may aberya po ito, ha? Ewan ko lang, ha? Ewan ko lang po, ha? Kasi kung ang mga testigo po ang magsasalita ngayon, mukhang mayroon po talaga problema ito. Ha? Nag-start na ba? Wala pa eh. Tingnan nga natin sa iba. Teka lang po, i-check po natin sa ibang ano. Kasi chinek ko, wala pa eh. Anyari? Kasi sobrang late na po sila pag hindi pa nag-umpisa. Wala pa rin po eh. Anyari? Wait lang po mga kaibigan, check lang po natin guys ha. Wala pa rin oh. Ang dami na nag-antay oh. Anyari? Opo, tinignan ko po si Attorney Harry Roque. Wala pa rin. Nagsasalita lang po si Attorney Harry Roque guys, pero wala pa rin, hindi pa rin. Hindi pa rin nag-umpisa yung ano, yung no session pa, nakalagay, no session, Ito, pinapanood ko po si Attorney Harry Roque, nakalagay, no session. Ayan, ibig sabihin, wala talaga. Ano nangyari? Ha? Anyari? Nako, delikado po ito mga kaibigan ha? Puntahan nga natin si Attorney Harry Roque. Wait lang subukan natin yun. Pakinggan po natin si Attorney Harry Roque guys habang nag-aabang po tayo Kasi grabe naman. Anong petsa na? Tingnan natin. Anyari? Ba't ganon? Mukhang may problema po ito guys pag ganyan. No? Sa tingin ko lang mukhang may problema po ito. Kasi dapat plain na
malaking dagok ito sa prosecution kasi yung pagpapakita ng video na yan medyo talagang masyasya ka naman kung makikita mo yan at kung tatanggapin mo sa konteksto na inopen ng prosecution na si Tatay Digong mismo nag-o-order ng patayan na yan. So kung mapapatunayan talaga na hindi ganyan yung konteksto ng ebidensya na yan, una-una, bakit kasi piniresenta na paggamit ng maling konteksto? Meron talagang intensyon na linlangin ang mga maestrado. At pangalawa, magpapakita dyan na hindi si Tatay Digong ang nag-order. Kung hindi, napapanood lang niya kung ano ang gawain ng mga kapulisan. At sa tingin naman niya, yan ay isang lehitimong police operation. So ang mahirap talaga sa prosecution, sila ang dapat magpresenta ng sapat na ebidensya na nagpapakita na ang mga naging biktima ng drug war ay mga sibilyan at sila ay tinarget dahil sila ay sibilyan. So, wika nga ni Maharlika, nung kami nag-joint broadcast, dapat ipakita nila na si Tatay Digong ay gumurgor na mga biktima ng drug war dahil sila ay mga inosenteng sibilyan. Pero kung ang pagpatay naman sa mga biktima ng drug war ay dahil sa lehitimong police operation at hindi sila tinatarget dahil sila ay lehitimong mga sibilyan, wala pong dahilan para magpatuloy ang paglilitis kay Tatay Digong. Now, by and large, sa tingin ko, ang pinakamalakas, bagamat kulang talagang ebidensyang piniresenta nila ay dun sa Davao Death Squad. Dahil di umano, meron daw silang ebidensya na si Tatay Digong bumuo at siya mismo ang nagdidirect ng mga operasyon ng DDS. Siya mismo daw ang nag-a-approve kung sinong titirahin ng mga miyembro ng DDS. Siya daw mismo nagbibigay ng pabuya at siya mismo nagbibigay ng garantiya na hindi sila malilitisan. Ang problema nga lang is mapapatunayan ba nila lahat ito? Gayong isang napakalakas di umano na ebidensya nila, yung video nga ay sinasabi ng may-ari na mali ang konteksto. So kung talagang tama yung sinasabi ng may-ari ng video na mali ang konteksto at hindi yan na dapat gamitin bilang ebidensya na si Tatay Digong ang nagsusupervise ng hearing. Kung hindi, tinitignan lang niya yung mga bagong installed na monitors, na CCTV monitors sa istasyon ng pulis ng Davao City, wala pa rin silang ebidensya. No? Dahil yan naman talaga yung tanging ebidensya ipinakita nila. No? Other than yung sinasabi nila na meron silang mga anonymous na mga testigo. Hindi naman po pwede na magpapasya ang husgado na sapat ang ebidensya sa pamamagitan lamang ng anonymous na mga testigo. Dapat talaga ipakita nila kung sino yung testigo nagsasabi na bumuo, nag-direct, nagbigay ng pabuya, nagbigay ng garansya ng non-prosecution ay si Tatay Digong mismo. Kapag hindi nila napatunayan yan, hindi pa rin lilipad yan. Now, bakit ko sinasabi na ito na yung pinakamalakas nila bagamat kulang pa rin yung substantial evidence? Kasi yung sumunod na mga ebidensya na dinetalye ng dalawa pang prosecutor ay nakatutok sa war on drugs. Ang ginagamit nilang ebidensya mismo yung dokumento na nagsasaad kung paanong operasyon ng war on drugs. Ako naman po, salita na ni Tatay Digong, talagang dinidepensahan ko naman po yung war on drugs at ayon din sa opisyal na dokumento na galing sa PNP kung ano ang war on drugs. Ano ba ang war on drugs? Well, ang war on drugs po isang pulisiya lamang para palakasin ang visibility ng pulis sa ating mga komunidad, no? Lalong-lalo na doon sa mga mahirap na tagalungsod na mga lugar kung saan laganap ang bentahan ng droga at ng shabu. At ang nakasaad lang naman doon sa Operation Takhang, Operation Double Barrel ay yung maalawakang presensya ng mga kapulisan, kakatok ang mga tao ang mga pulis sa mga bahay-bahay at makikiusap doon sa mga pinaghihinalaang mga pushers na sumuuna. Now, ang hirap po dito sa pulisiya nito, unang-una, meron silang sinasabi na high-value targets na yan daw ay kill order. Pero paano naman talaga ilalagay ng kapulisan sa isang nakasulat?
The International Criminal Court is now in session. L'audience de la Cour pénale internationale est ouverte. Please be seated. Veuillez vous asseoir.
Bonjour à tous.
Good morning, everyone. I'd like to welcome everyone in the courtroom, as well as those who are listening in from outside the courtroom. Court officer, please call the case.
Your Honors, situation in the Republic of the Philippines in the case of the prosecutor versus Rodrigo Roa Duterte, case reference ICC 0121-0125, and for the record, we are in open session.
Merci beaucoup.
Thank you very much. I would like to ask parties and participants to confirm that those present in the courtroom today are the same as the people in attendance on Tuesday. Mr. Prosecutor, the prosecutor. Good morning. The OTP is represented by the team. Mr. Ido Duke, Associate Trial Lawyer, is one additional. I myself, I am back after a short absence. The presiding judge, thank you very much. Legal representatives of victims, Ms. Masida. Ms. Masida, thank you. Good morning, Your Honor. It is the same team as Monday, not Tuesday, but Monday. The presiding judge, thank you very much. We can now turn to the defense. Mr. Kaufman. Good morning, Madam President, Your Honors. It is the same lineup as previous days. I will go no further than that in French. The presiding judge, thank you very much. We can now move on to the defense and their submissions on the merits. Mr. Kaufman, you may address the court.
Now, before I start, I would like to make one general comment, and it's a comment which every defense counsel who appears before this court is obliged to make. So if the mainstream media in the Philippines and the NGOs reporting on his case today report anything about the defense's submissions, I hope that they will at least communicate the following faithfully. The defense does not disrespect the soul of any deceased person, nor does it make light of the loss of life. Any criticism made by us today will not be levelled at the loved ones of those such as the tearful relative who I saw in the gallery here on Tuesday. The defence's criticism will be confined only to the prosecution's document containing the charges, which governs these proceedings, not what has been reported elsewhere in the media. It's not the defence's role to give an alternative narrative, nor to give an explanation for the facts and figures presented by the prosecution. The defence's role is simply to persuade your honours that Mr. Rodrigo Duterte should not remain in detention for years to come, simply because the prosecution cannot make out substantial grounds to believe that this individual committed the crimes with which he is charged. Now, Mr. Julian Nichols confidently said the other day that you can ignore Rodrigo Duterte's speeches. Disregard every speech ever made by Mr. Duterte, he said. Throw them all out. There is still ample evidence of the substantial grounds based on the other evidence. That's transcript T4, page 45, lines 5 to 6. Helpful advice from no less than the day-to-day prosecutor in charge of this case, because we will show that the evidence is not substantial, rather totally inadequate. But in any event, since I can leave no stone unturned, I now turn to those speeches. Now, if there's one thing that I've learned from the domestic media coverage of this case, it is that journalists and their editors have a tendency to fixate on the salacious elements of a person's speeches while ignoring the less interesting parts. And so it was with Rodrigo Duterte. The prosecution has had its opportunity to show you a selection of these speeches and seems to believe that the more they show, the greater the chances of convincing your honours to confirm the charges. But what the prosecution has not told the public is that in its document containing the charges, which governs these proceedings and nothing else, it has only supplied 20 of these speeches as proof of criminal intent. And as I mentioned in my opening statement, 10 of these speeches, including 2 referred to by the deputy prosecutor, actually contain an exhortation to the use of lawful self-defense. Thereafter, we found a further 35 speeches, which will be found at tab 9, 11 to 26, 29 to 35, 37 to 41, 43 to 46, 137, and 152. Now, this is obviously not a competition. The point we really merely wish to make is that relying on the former prosecutor's speeches as a means of proving criminal intent is impossible. Now, I'd like to go back to that one speech which I promised the other day to show you. This is a speech, the second speech that the deputy prosecutor referred to in his opening statement. And this refers to the responsibility that Mr. Duterte said that he would shoulder, promising to shield rogue officers from prosecution. If we may, the first of these speeches, and I quote what the deputy prosecutor read from this speech. So that police is under the DILG, so I have to believe the story of the police, for simply they are my subordinates and I am ultimately responsible for their deeds. Now let's look at what the deputy prosecutor didn't state from the same speech. And the order is simply this: go out, arrest them if you can, but if there is no peaceful method of doing it and you are presented with violent resistance, thereby placing your jeopardy in your life, you shoot, well, the son of the bitch. Mr. Duterte's language, obviously, but nevertheless an exhortation to lawful self-defense. Let's have a look at another one of the prosecution's speeches mentioned in their pre-confirmation brief. Once again, on shielding criminal agents from prosecution. I quote, This is, I apologize, PHL-OTP 00001127 at page 5. And I quote, "But if you do your duty, do not worry about cases. I'll protect you. Believe me. That's why I will protect them. And if there's somebody who will go to jail, it's me. I will assume full legal responsibility." Now let's have a look at the exonerating element, which comes right underneath the allegedly incriminating element. He said, "Just do it right. We have our trainings that you can only kill if your life is in danger, and you are there performing the duty of a law enforcer." That's about it. Now I will turn to one of our speeches that we found in our research, one of the 35 that the prosecution didn't find. And I will terminate there because we have the rest, which we've referred you to in the tabs. So this is an exonerating speech which the prosecution either missed or ignored because it doesn't suit its case. And it was a speech which was made right at the start of the presidency, which could be seen as setting out the standard for his presidency. Mr. Duterte said this, "I promised them I will suppress crime and take control of the drug situation, which was really running wild in our country today. Make no mistake about it. I repeat again for all and for everybody's consumption. Do not kill if you are not in danger of losing your life." Well, it goes on. You can see it there on the screen. Well, of course, the prosecution knows that we are going to argue that many of these speeches, in fact, the majority of these speeches, I would say, contain this exhortation to the lawful use of self-defense. And the learned counsel, Mr. Edward Jeremy, for the prosecution, tried to get around the problem by inventing the novel concept of the elastic mouth, which out of one side emanates the nasty truth, while out of the other side issues the supposedly disingenuous advice for the police to act in self-defense. But I ask your honors and the people of the Philippines listening in today, how many times did you hear the former president state at the beginning of any address that he had a speech of 2 pages prepared, but to his regret, it didn't come from the heart. And then he would proceed to speak at length, sometimes for an hour or more, in his own uniquely colourful and crusty language, exposing his homespun theories on crime control, swearing a bit here, boasting a bit there, and generally delivering a speech more akin to Finnegan's Wake than a Gettysburg Address. That does not suggest crafty design, hinted at by Mr. Jeremy, quite the opposite. Mr. Jeremy's resort to the say one thing, mean another thing theory is complete supposition. It is not a legitimate argument because it implies that one cannot rely on anything coming out of Mr. Duterte's mouth, and that does not help the case for the prosecution at all. Well, that's about it for the speeches. I'll now turn to crimes against humanity and the contextual elements. And here I would like to start off by addressing the requirement that the acts of murder alleged be committed as part of or in themselves constitute a widespread or systematic attack. The second requirement is that these acts of murder be directed against the civilian population. With respect to the unique ICC requirement of an organizational policy, I would suggest that this concept has been conflated with the common plan, and as such, I shall address the matter later in my submissions. So, to start by reference to the widespread or systematic nature of the attack, I would like to draw your honour's attention to the fact that Count 1 contains 9 incidents of murder in one city, Davao, hardly widespread. Ms. Robin Croft, in her submissions yesterday for the prosecution, Tuesday, told you that the widespread nature of Count 1 was evidenced by the multitude of bodies in a quarry, a mass grave. Well, the prosecution and the authorities in the Philippines have had years to continue its investigations since the judicial warrant was reimposed. I mean, they could have dug up the entire city of Davao, but all they have managed to produce, the prosecution on the matter, is a reference to Leila de Lima in a Senate committee where she talks about the discovery of a few human remains which could have belonged to World War II Japanese soldiers. The same goes for another witness's outlandish assertion that bodies were thrown into the sea off the coast of Davao. Well, the whole Gulf could have been dredged, but not one executed corpse has surfaced. As for counts 2 and 3, Ms. Croft showed us some maps with coloured dots to indicate the magnitude and geographical spread of what the prosecution alleges, without, of course, proving that they were extrajudicial killings not countenanced within the 49 incidents. Indeed, for this reason, there is nothing to link the charged incidents, those 49 incidents, to the wider picture. According to the appeals chamber, which confirmed a pre-trial chamber ruling on the matter in Bagbo, filing number 432 in the case record at paragraphs 35 to 36, any factual allegations outside the charged incidents, in this case masses of generically alleged extrajudicial killings, must be proved to the required standard. And for this, NGO reports, academic statistics, and media articles are, as a rule, considered insufficient. Ms. Croft also screened images taken from the Duterte administration's PDEA report for the years 2016 to 2019, if we can pull that up now, which cite figures of the number of deaths of drug personalities in anti-drug operations without proving that they were illegally murdered, but she neglected to contextualize these numbers by reference to other parts of the same report which show that in comparison to the number of arrests and operations conducted, the number of deaths are minimal. Please, if you will, show a bar chart that we have helpfully prepared with the figures and a pie chart with the percentages. So, if I may just conclude, the only thing that is widespread here, or rather spread wide, is the utility of the prosecution's statistics. Now, turning to the civilian population, or the target of the attack, let me say straight away that the prosecution case theory, with respect to the definition of the targeted population, is, to put it extremely politely, muddled. In layman's terms, the prosecution has hedged its bets by presenting two alternative propositions, hoping that this pre-trial chamber will settle for one of them. From paragraph 17 to paragraph 20, inclusive of its document containing the charges, the prosecution argues that Mr. Duterte launched an attack on the entire population of the Philippines, pursuant to a policy to neutralize persons perceived or alleged to be engaged in crime. In paragraph 21, however, this so-called attack is directed not against the civilian population at large, the whole population, but rather against a considerably smaller and nebulous margin of society, namely the alleged criminals themselves. Let us start by dealing with the first scenario, namely that the former president, whose loyalty and love for his country is and has always been beyond question, launched a wholesale attack on the whole population of the Philippines, on the entirety of his nation, including the very same people who put him into power. Such a suggestion is not just incomprehensible, it is quite bizarre. The reason for this rather strange assertion, so I submit, is grounded in the prosecution's latest brainstorm on the matter, which it set out last year in a brief, appealing a decision of this very same pre-trial chamber in the El Hishri case. And I do apologize in advance for the rather dull expose which will follow, but I do find it instructive to illustrate the chameleon-like nature of the prosecution's case theory. In this instance, Your Honours found that the civilian population attacked by El Hishri comprised prison detainees professing a certain political ideology. In so doing, Your Honours declined to issue an arrest warrant for El Hishri, where the victims of his crimes had been detained for totally unconnected and non-political reasons. Now, you might ask yourselves, why did the prosecution decide to appeal this decision? It was not as if it had been denied the arrest warrant for El Hishri that it had sought. Well, a key to the answer, so I believe, is to be found in the chronology of the events. On 10th February 2025, the prosecution rushed out its application for Mr. Duterte's arrest, believing that a unique opportunity to apprehend him had arisen. In this application, the prosecution defined the attack perpetrated by Mr. Rodrigo Duterte as being aimed at the entire population of the Philippines. Let us now fast forward to 10th July 2025. The pre-trial chamber, this same pre-trial chamber, ordered the arrest of Khalid al-Hishri for an attack on an objectively identifiable civilian population of detainees, while finding no justification to suspect him of crimes committed against a discrete subsector of that population, exhibiting characteristics distinct from those of the general population. Well, as you can guess, the prosecution didn't like that decision and hastened to appeal it. Not, I would suggest, out of any true concern for the purity of international humanitarian law, but rather because it put a spanner into the works of the Duterte case. That is, the only other active case that it is prosecuting before this court. After all, if we apply the resulting logic of Your Honour's decision in El Hishri to the prosecution's case theory in the Duterte case, at least as it stood as of 10 July 2025, then alleged drug pushers and alleged criminals would be deemed a separate, subjectively defined subgroup of the general Filipino civilian population, displaying different characteristics and, as a result, excluded as targets of the attack. So, 8 days passed between this decision of yours, Your Honours, and the notification of the confidential version of the prosecution's pre-confirmation brief on 18 July last year. And I'm prepared to wager that while beavering away with their attempt to appeal the El Hishri decision, the gurus on the top floor of the Office of the Prosecutor were also frantically discussing how to deal with this inconvenient fly in their conceptual ointment. They had to think of a way to accommodate this pre-trial chamber's ruling while not compromising their appeal. So, lo and behold, and rather unsurprisingly, the pre-confirmation brief contained a new feature, namely the second scenario to which I referred earlier, that the target of the attack was not the Filipino as a whole, but the suspected drug pushers and criminals. Now, even if the former president did promulgate an organizational policy of eliminating suspected criminals and drug pushers, which he most definitely did not, this policy did not and could not constitute an attack directed against a clearly definable civilian population. Firstly, the segment of society victimized cannot be said to display objective characteristics distinguishing them from other members of society and thus rendering them susceptible to an attack. After all, how does one define a suspected drug pusher or suspected criminal for the purposes, let us say, of count 1, where there were no HVTs or high-value targets or PRD lists or kill lists or what have you? It is not as if criminals have identifying features such as a shifty look or a 5 o'clock shadow or a sack marked swag. In other words, the definition suspected drug pusher or suspected criminal entails the exercise of discretion on the part of the perpetrator implementing the organizational policy. It is a shifting and mutable concept. It is a subjective determination. In our submission, there has to be, at the very least, an objectively discernible characteristic which unites the members of the targeted group such that they can be deemed a civilian population for the purposes of the attack. Leaving the determination of membership of a civilian population to the people who pulled the trigger introduces a degree of random selection, and as cited quite clearly in the Al-Hassan confirmation decision at paragraph 149, the prosecution must prove that the attack was not directed against a limited group of randomly selected persons. This ruling, Your Honours, was the expression of the law as it had stood for many years, ever since the decision authorising an investigation in the Kenya situation, where at paragraph 81, the pre-trial chamber defined a civilian population as a group sharing, and I quote, distinguishing features, and added as follows, and I quote again, the prosecutor will need to demonstrate to the standard of proof applicable that the attack was directed against the civilian population as a whole and not merely against randomly selected individuals. So let us ask ourselves whether the alleged attack in this case was directed at the population as a whole or at a subjectively defined subgroup of perceived or alleged criminal offenders. The minute the distinguishing features of the civilian population in question are defined through the application of subjective criteria, the targeting process becomes completely random. The targeted civilians are perceived criminals, but perceived to be so by whom? Is it not the case that one man's despicable criminal is another person's righteous saint? In fact, have we not heard from the civil society that many of the victims were not drug pushers or criminals, but innocent members of the local community? To me, and as a matter of logic, it would appear that the targeted population in the Duterte case was selected randomly, even according to the prosecution's own witnesses, who talk about quotas of neutralization that had to be met, and their motives for target selection, which had frequently nothing to do with suspected criminality, but rather personal vendetta, or on one occasion, just because the victim had cheated at cards. With that, Madam President, Your Honours, I conclude the chapeau or contextual requirements of crimes against humanity. And I will now turn to the modes of liability or means of perpetration. Now, I have racked my brain for many a month, pondering one question. If Rodrigo Duterte was so shamelessly brazen as to broadcast his murderous intent in public ever since he was the mayor of Davao, why did it take the ICC prosecution almost 4 years to open an investigation after Rodrigo Duterte pulled his country out of the International Criminal Court? After all, why did the ICC prosecution not just save itself all the hassle of its jurisdictional problem, a fundamental issue that still plagues it and remains to be resolved by the appeals chamber? We won't talk about that today, obviously. But why did the prosecution not seek to initiate its official investigation within the 1-year withdrawal period, especially given the fact that Mr. Karim Khan, the victim's representative embedded in the role of chief prosecutor, had received judicial authorization to interview at least one of the criminal cooperating witnesses substantiating the crimes of the Davao mayoral period? Well, for me at any rate, it didn't take too long for the penny to drop. As I mentioned in my opening statement, the prosecution knows that it is not enough simply to assert that Rodrigo Duterte said outrageous things and that deaths occurred, and so, as a result, he must be criminally responsible. There is a requirement for what is called a causal nexus. The prosecution has to show which one of Duterte's statements, orders, or commands were given to a specific individual who then went out and pulled the trigger or communicated the command to someone else who also went out and pulled the trigger, killing one of its 78 identified victims. That would have been the classical way to prove a causal link between stuff that came out of Rodrigo Duterte's mouth and the deaths pertinent to the case. That would have been ordering under Article 25(3)(b). But the prosecution cannot show such a causal link. They've never been able to do that. They show you a lovely pyramid. It's on the screen, with Duterte at the top, the co-perpetrators underneath, the DDS handlers underneath them, and the hitmen perpetrators at the very bottom. To quote Mr. Julian Nichols, how cute. But what the learned prosecutors can't show you is the connecting line between Duterte at the top and the next level down, comprising the so-called co-perpetrators. I hope Ms. Croft will forgive me for vandalizing her screenshot, but there you have it. That is where the apex slips off the pyramid of Giza. The most they can do is allege that their cooperating witnesses who pulled the trigger and whose credibility is about as worthless as a devalued peso understood that killing is what Duterte would have wanted, or that they had no choice but to comply because that was what was expected of them by their handlers, or other such similar expressions of a totally subjective sense of obligation. But as they know, not one of the 49 incidents mentioned in the document containing the charges manifests such a causal link between a speech, an order, and one of the charged incidents. I will state it for the record. In fact, I will state it a number of times during my submissions. There is no smoking gun in this case. And that is not for want of a desperate attempt to find one on the part of the prosecution with all their leading questions when they interviewed their criminal cooperating witnesses. Not one witness relevant to any of the 49 incidents with which Mr. Rodrigo Duterte is charged will testify that he received a direct order from the former president to go out and kill someone. Let us just digest this. All those speeches where the former president made various threats to kill, but not one demonstrable incident set out in the prosecution's document containing the charges, which details an act of murder committed as a result of a direct order given by him. This, in and of itself, should be sufficient to convince any reasonable bystander observing the conduct of these proceedings that Rodrigo Duterte is innocent of these charges levelled at him. It is for this reason, and because of the complete lack of reliable cooperating witnesses, that the prosecution has alleged not one, but a plethora of theories as to the means of perpetration, to link the crimes allegedly committed to the person who is far removed from the incidents of murder and who has been targeted for prosecution. And I say targeted for prosecution. Normally, I would say that such a multiplicity of legal theories speaks to a lack of clarity and prosecutorial uncertainty. Indeed, some of these modes of liability, as pleaded, contradict each other as a matter of logic. Nonetheless, I would like to make the following general observation. As the defense has progressively reviewed the massive databases of evidence disclosed, it has become increasingly apparent that given the absence of direct evidence directly implicating Rodrigo Duterte, or even indicating his participation in or control over any one of the 49 incidents alleged in the document containing the charges, the prosecution has resorted to papering over the cracks with human rights reports, press statements, hearsay, and of course, Mr. Duterte's bluster and political hyperbole. And where these documents are not suffice, the prosecution has resorted to the time-worn theory of indirect co-perpetration, Article 25(3)(a), of which the parameters, I would respectfully submit, are still subject to dispute. So I will now turn to this mode of liability, which is the principal mode of liability levelled at Rodrigo Duterte. As we all know, in order to prove criminal liability through indirect co-perpetration, there is a need to show a common plan upon which the suspect and his co-perpetrators, because you need co-perpetrators for indirect co-perpetration, a plan on which they mutually agreed. And that common plan must, without exception, have a criminal element. As I have already stated, the only plan in play was not just totally legitimate in nature, but was, in addition, wildly supported by the Filipino electorate, which ensured that Mayor Rodrigo Duterte's governance of Davao City throughout the years would thereafter put him into the Malacanang. According to the prosecution, the criminality of the common plan expressed itself as follows, and I quote from their documentation: an agreement to neutralize alleged criminals in the Philippines, including those associated with drugs, through violent crimes, including murder. Well, they really covered all options there. The existence of such a criminal plan is of course, entirely preposterous, and, I should say, totally denied. I would suggest that the prosecution cannot point to any particular point in time where there is direct evidence indicating that even two of their so-called co-perpetrators actually met to agree to such a preposterous scheme. As such, the plan cannot be described as common to anyone. If anything, it's an artificial construct derived from the 10 assertions which are set out in paragraphs 24 to 33, inclusive of the prosecution's pre-confirmation brief, all of which comprise circumstantial evidence of the lowest quality, pointing to a mutually agreed design which exists in the prosecution's mind and nowhere else. Of course, there is nothing wrong with construing the existence of a common criminal plan from circumstantial data. But the cardinal rule of such a category of evidence is that the incriminating facts derived therefrom must be the only reasonable inference in the circumstances. What we can say with a degree of certainty which reaches more than a substantial degree of certainty is that no inference can be drawn from the comments of crime-based perpetrators. And to hammer the point home, I would like to screen you just a selection of excerpts taken from the interviews of a number of the prosecution's criminal cooperating witnesses. Or witnesses. Where are they? Number one. Interviewee. At least more or less than 10 buy-bust operations. Where somebody was shot, asked the interviewer. Yes, sir. Interviewer 1. Okay. And on those 10 occasions, was the shooting justified? Interviewee. Yes, sir. Number 2. So, if he shot at us, we would also shoot back. But if he were to stab at us with a knife, then we wouldn't. We wouldn't shoot a person that was holding a knife. And the third one. Witnesses who said, the PNP never said kill those people. Another quote. From what I recall of the incidents that I was at, all of them had guns, and they were pointing them at the pusher buyers, or they were pointing their guns at the pusher buyers. At the operations I was at, I'm talking about the operations I was at. The reason that they were killed was because they were pointing their guns at us, or they were firing their guns at the pusher buyers. That's from the prosecution's own witnesses. Now, let us analyze the other circumstances as set out in paragraphs 24 to 33, inclusive, to see whether a meeting of minds between co-perpetrators is indeed the only reasonable inference in the circumstances. The first indication, and that is that in the late 1980s, in other words, 20 years before the charges in this case, Mayor Duterte allegedly instructed civilian confidants and local police to neutralize. And I stress to neutralize and not to kill criminals. That's what's stated in the PCB. And that he provided weapons and funds for this purpose. Now, I would say that there is nothing untoward in providing policemen or civil volunteers with weapons to carry out their lawful duties. That's what happens in my country. The prosecution has not shown us how arming civilian volunteers is actually illegal. And the burden of proof rests on it. After all, one does not fight crime with kind words and gentle admonishments. The fact that these conscripted civilians understood the words to neutralize to mean to murder is not something for which Rodrigo Duterte must be held responsible. Trust me, had any one of the unreliable, insider, criminal cooperating witnesses substantiating the assertions made in paragraph 24 of the pre-confirmation brief said that Rodrigo Duterte gave a direct order to murder one of the 78 victims, the prosecution's lawyers would have written it into their charges, point blank. But they did not. And furthermore, any false allegation made by cooperating criminal witnesses made years before the charged incidents and without the time frame of the case does not constitute pattern or similar fact evidence indicating a predisposition to murder criminals. Accordingly, the allegations concerning the activities of the so-called Davao Dev Squad, formerly the so-called Lambada Boys, are irrelevant both to proving a criminal plan and that such a plan, more importantly, was common to any of the so-called co-perpetrators mentioned in the document containing the charges and released a few days before the confirmation hearing in a lesser redacted version of the PCB. Now, thinking like a prosecutor, I would say that the reason why the prosecution has fixated
Anong nangyari? Ano nangyari? Pinutol na naman nila. Ito na ba ngayon sinasabi natin eh? Pinutol na naman po. Basta pag meron pong sinabi, si Attorney Nicholas Kaufman, pinuputol nila. Katulad po nung pinakaunang araw, meron siyang sinabi patungkol kay Karim Khan, pinutol din nila. Ito naman, meron po siyang sasabihin patungkol sa ICC, pinutol na naman po nila, guys. Anyari? Sabi na nga ba eh? Di ba? Sabi na nga ba eh? Ano pong nangyari mga kaibigan? Wala na pong transmission? No broadcast na po? Pinutol po, guys, pinutol. Ganon talaga sila, pinuputol po nila mga kaibigan, no? Basta pag si Attorney Nicholas Kaufman po ang nagsasalita, talagang kina-cut off po nila, guys, para hindi natin marinig. Katulad nung kay Karim Khan, pinutol din nila. So, abangan po natin kung anong mangyayari dito, kung tutuloy pa ba ito. Ha? Anong nangyari? Sabutahin na naman! Ano ba yan? Ha? Pinatayan po tayo ng broadcast mga kaibigan. Agoy, ginorgor na naman po tayo. Bakit po pinutol? Hindi po ito problema ng Pilipinas, no? Wala po tayong problema dito sa Pilipinas. Sila po mismo ang may problema doon. Kasi po walang broadcast, guys. Sayang, talagang may sasabihin na sana siya. Wala na, hindi na natin po marinig yun. Kasi pag bumalik po ito, guys, wala na, tapos na po yung hearing. Pangalawang session na po. Di ba? Kasi alam ko, 1 oras lang po ito eh. Oh. Ayaw po nilang pagsalitain. Yes, mukhang ayaw nilang pagsalitain talaga. May something talaga. Di ba? Kasi ganun sila eh. Pag masyado na pong sensitive, guys, ang topic, talagang pinuputol nila mga kaibigan. Kumbaga siguro napapahiya siguro ang ICC. Ha? Hindi kaya? Sa tingin ko parang napapahiya kasi sila eh. Di ba? Nako, ito na naman. Kasi ganun din yung nangyari nung unang araw eh. Meron na dapat siyang i-reveal si Attorney Nicholas Kaufman, pinutol din nila patungkol kay Karim Khan. Kasi tinanong si Attorney Panelo diyan eh. Hindi rin po alam ni Attorney Panelo kung bakit po pinutol. Kasi andun po sila, 'di ba? Nasa loob sila ng ICC. Nag-observe po sila, guys. Pero ito na po yung hinihintay natin. Anong nangyari? Di ba? Pero yung mga prosecution po, hindi nila pinutol, guys. Bawat salita ng prosecution, hindi nila pinutol. Napakahaba nun. Di ba? Napakahaba ng salaysay ng prosecution. 3 beses, 3 session po, umabot po ng almost 11 p.m. Hindi nila pinuputol. Ngayon,
The fourth supposed indication of a common criminal plan.
Wala na.
That is set out in paragraph 27 and mentions that on the very day that the former president appointed Ronald De La Rosa Bato as the chief of Philippine National Police, De La Rosa issued a pre-drafted command circular number 16 of 2016 on 1st of July of that year, formally launching the anti-illegal drugs campaign nationwide in express pursuance of Duterte's campaign promises. There is no dispute that CMC number 16 of 2016 mentions Project Double Barrel, which was indeed modelled after Davao City's policing strategy and was directed at the neutralisation of illegal drug personalities nationwide. But here we come to the crux of the prosecution case. The manifestation of the criminal plan in writing. Neutralisation as a euphemism for murder. Ms. Robin Croft certainly thought so when making her submission on behalf of the prosecution, highlighting the word in bright red and presenting us with a slide where the word neutralisation forms an integral element of the common plan. To import an element of criminality into what would otherwise be a perfectly anodyne legal document, the prosecution resorts to relying on speeches and interviews given by Ronald De La Rosa Bato within a day or two of him being appointed the chief of Philippine National Police. For example, in an interview relied on by the prosecution at footnote 136 of the pre-confirmation brief, De La Rosa explains how tok hang means knock and plead, and that it is a totally legitimate police strategy. However, the citations relied on by the prosecution to infer that tok hang was a criminal modus operandi are completely taken out of context. I shall just cite one question and answer from the media interview on which the prosecution relies at paragraph 27 to prove that De La Rosa, when talking about instilling fear in the hearts of drug users, was actually proposing a policy which was anything but criminal and totally supportive of the main tenet of the defence, namely that the only use of force would be that envisaged by way of self-defence. And I quote, question, Sir, you mentioned about instilling fear. When you instill fear, how do you ensure that you do not violate human rights? Answer. Good question. We will see to it that the police operational procedures are being followed in every legitimate police operations. When they see that the police are really determined to go for them legally, he stresses the word, and many of them go down, maybe they'll get scared. That's PHL OTP 000-16403 at page 13. In any event, what the prosecution has not told you, and what it has not shown you by way of its opulent images on the video screen, is that the supposed criminal blueprint set out in Command Circular 2016, number 16 of 2016, is totally negated by the content of the document itself. Let us take a look at paragraph 8E and F of the very same Command Circular, number 16 of 2016, which states quite clearly that all operations should strictly observe the rights of the accused enshrined in the Philippine Constitution, as well as international law and human rights. I ask you, did Mr. Edward Jeremy, counsel for the prosecution, in his very eloquent and gilded address, not screen this part of the Command Circular? After all, this Command Circular, as elaborated by Ms. Robin Croft, was the very essence of his criminal common plan, in writing. This is the basis, so Mr. Jeremy stated, for the criminal agreement to kill high-value targets. And if that were not enough, the lawfulness of Command Circular 16 of 2016 was reiterated 3 weeks later on 22 July through the initiation and issuance of PNP Investigative Directive number 12 of 2016, which set out additional policies and guidelines in the conduct of double barrel. I think there, Madam President, if I may, we can take a break, obviously with your permission.
Bien sûr, maître, je vous remercie, Kaufman, je vous remercie beaucoup.
Thank you, Counsel. Thank you very much. If you can also indicate the numbers of the documents that you have referred to, that would be good. Thank you very much, says Judge Motok. We will take a break now and resume at 11:30. Thank you very much.
Ayan po mga kaibigan, nag-break time po guys. Inaantok na po si Motok. Nagulat si Motok, inaantok na siya eh. Nagulat siya kay Attorney Nicholas Kaufman. Sabi ni Nicholas Kaufman, oh, shall we have a break? Shall we take a break? Madam Motok? Nakita nyo yung reaction po ni Madam Motok mga kaibigan? Ha? Nakita nyo ba guys? Pinakita po sa screen kung paano po ang kanyang reaction sa mga pasabog po ni Attorney Nicholas Kaufman. Makikita nyo guys, talagang ibang-iba yung hitsura niya, no? Parang hindi siya pa nga paniwala sa mga sinasabi ni Attorney Nicholas Kaufman. Oh, bravo po, no? Palakpakan po natin mga kaibigan. Andiyan pa ba kayo mga suki? Ha? Gising pa ba kayo guys? Palakpakan naman natin si Attorney Nicholas Kaufman sa napakaganda ng kanyang presentation po, no? Napakagandang explanation po. Talagang pwede po na masasabi po natin guys. Wait lang anong nangyari dito? Napakaganda po ng kanyang explanation at saka paliwanag po mga kaibigan na ito po mga prosecution guys ay talagang gumagawa-gawa lang po sila ng kaso. Kasi in-explain naman niya lahat no? So syempre mga kaibigan, no, nagpapasalamat po tayo once again sa sobrang galing po ng ating defense, pero wag po tayo masyadong wag po tayo masyadong masaya. Wag po tayo masyadong mag-expect dahil alam naman natin guys na ito pong mga decision ay decision pa rin po ng mga judges, 'di ba? So break muna tayo hanggang anong oras daw siyang anong oras sinabi niya? Tingnan nga natin kung anong oras ba babalik. Wait lang Check lang po natin guys kung anong oras tayo babalik. Dahil kanina po late na sila no? Sobrang late na po yung kanina. Babalik po ng alas 7. So meron po tayong 30 minutes. Meron po tayong 30 minute break, no? Opo, hello Kitty, no? Let's hope for the best. Daisy Capistrano, bayad ang mga judges. Unite in prayer, God moves miraculously to give the free PRD and the nation Philippines free from bondage of corruption and crimes. Ayan. Kabado po, kitang-kita naman Di ba? Nakitang-kita nyo naman, di ba? European time po, 11:30, yes. Babalik po tayo ng mga mga 30 minutes. Tingnan natin anong oras na. Anong oras na ba sa Netherlands? 11:30 na ngayon, di ba? So babalik tayo maya-mayang konti. Okay. So babalik tayo ng mga ilang minutes? 30 minutes? 20 minutes? 11 na ngayon sa kanila. 11:30 na. Netherlands time. Ayan 11:30 AM. So anong oras sila babalik? Mga alas 12 siguro. Hindi. Tama, mga alas 12 siguro, no? Kasi tatlo to no? Tatlong session po ito, no? Ito yung una, tas mamaya pangalawa na. Okay, so break time muna tayo mga kaibigan. Magkita-kita po tayo mamaya. Okay, muna kayo, mag-refresh muna kayo, kain muna tayo. 30 minutes po, no? Kain muna tayo, guys. Alright? mga kaibigan, we're back. Nakakain na ba kayong lahat, guys? Ano pong nangyari mga kaibigan? May nakalagay po dito ngayon, ano ba to? Private or closed session? Anong ibig sabihin nito? Parang parang executive, no? Meron din pala silang ganun doon. Parang sarado yata yung nila, ha? Kasi nakalagay po dito, private or closed session. Ano ibig sabihin nito? Kasi kanina po, sabi po ni Attorney Nicholas Kaufman na pwede daw pwede tayong mag-break time. So nag-break time po sila. Siguro nasa mga 30 minutes, lumagpas na yata ng 30 minutes. Kasi ang nakalagay po dito mga kaibigan, babalik daw sila ng 11:30. So lumampas na naman po sila sa oras kasi alas 12 na po. Pero nung binuksan ko po guys, nung tiningnan ko po yung wait lang yung tiningnan ko yung pinaka nila, kahit sana ko pumuntang mga live, ang nakalagay po mga kaibigan, wait lang ito po private or closed session. Kahit saan po ako magpunta guys, ganun din. Ganun din yung nakalagay, no? Ewan ko lang kung bakit po. Baka siguro private, siguro to. Baka, di ba, meron po tayo dito yung tinatawag na executive session. Oo, baka siguro ganun din yung para sa kanila, no? Ewan ko lang kung bakit po nila gagawin ito. Bakit po sila magpa-private conference? O kaya private or closed session? Ano bang ang dapat hindi nila i-disclose? Baka siguro ito may suspetsa po ako guys, Ito po. Opo, parang executive session nga. Ito suspetsa ko lang Baka siguro mga kaibigan, kaya po nila ito i-close guys. Baka ito na yung sinasabi natin na baka sasabihin na po ni Attorney Nicholas Kaufman yung patungkol po sa nangyari dito sa Pilipinas, yung kay yung pasabog ng mga ex-marines, o kaya yung yung $2 million na di umano'y natatanggap ng mga ICC investigators. Kasi hindi mo pwedeng hindi kasi kasama sa kaso yun no? Parang ang tinatalakay lang po dito sa ICC guys, yung crimes against humanity, no? Yun lang po yung topic diyan. Pero kung ipa-private or closed session po nila, ibig sabihin meron po silang ibang pinag-usapan siguro na hindi po related dito kasi off topic yun kumbaga irrelevant, kaya closed session. Parang gano'n. Ito lang, suspetsa ko lang kasi nga nakakapagtaka bakit biglang closed session? Di ba? Wala naman siguro dapat tawag dito yung parang confidential. Maliban lang siguro mga kaibigan, baka meron na siguro mga testigo. Baka lumabas na siguro yung mga testigo, pwede rin. Either way, no? Maaring yung pasabog ng mga ex-marines ay nakarating na po sa ICC. Kasi syempre, iba na ngayong technology. Di ba? Sa social media nila, makikita mo na kaagad Or baka siguro, kaya siguro private or closed session, baka andyan na yung mga testigo. Kasi, ang nakalagay doon, bawal pangalanan at bawal ipakita ang mga mukha. So, kaya siguro nila ito private or closed session. Pero hindi ko lang alam ewan ko lang po. Dahil dapat nag-umpisa na ito. Kasi ang oras po sa Pilipinas is 7:09 PM. Ang nakalagay po mga kaibigan sa kanilang oras is 7 PM babalik. Pero hindi pa naman masyadong late Baka siguro nagko-conference lang, no? Baka siguro pinag-uusapan lang yung mga kung sino yung mga nabayaran. Ito na. Ito na po mga kaibigan.
So, Madam President, Your Honours, we were discussing Command Circular number 16 of 2016 and the issuance of PNP Investigative Directive number 12 of 2016, which set out additional policies and guidelines in the conduct of double barrel. This directive instructed investigative units on how to perform their responsibilities in the case of lawful restraint. At the executive and operational level, the Chief of the Philippine National Police, Ronald de la Rosa, Bato, publicly clarified in 2017 that neutralization means arrest. Furthermore, in an official transcript dated 28 October 2024, the former Chief of Police, De La Rosa, testifying before the Committee on Accountability of Public Offices and Investigations, testified that the term neutralization was anchored in the PNP Operational Procedures Manual, where it is specifically and strictly defined. Let us just have a look at what he said. And for your ease of reference, we will also display the said passage in the PNP Operational Procedural Manual to which De La Rosa referred, which incidentally was published in 2021. Neutralization, purposely to contain or stop the unlawful aggression of the offender. This may include an arrest, capture, surrender, or other acts to subdue the suspect. It strikes us as rather mind-boggling that the prosecution should have failed to appreciate the significance of this. It was aware of De La Rosa's speech because they disclosed it to us. But the prosecution's investigators clearly never bothered to read the procedural manual to which De La Rosa was referring. In fact, we know that they didn't, because it's not on their list of evidence. Within the judicial sphere, when the terminology was examined before the Supreme Court of the Philippines, in petitions challenging aspects of the anti-drug campaign, the government defended the circulars on the basis that they did not confer a license to kill. The Supreme Court of the Philippines, however, to date, has declined to issue any ruling declaring the campaign unconstitutional, has declined to invalidate circulars, and has declined to rule to date that neutralize or neutralization means to kill. The Supreme Court's treatment of the issue is particularly instructive. The court observed that the wording was neither novel nor introduced during the Duterte administration. It had already appeared, for example, in the 2014 revised PNP Manual on Anti-Illegal Drugs Operations and Investigation. In other words, the term formed part of the existing police vocabulary. The court further clarified that the mere inclusion of the term in a circular does not render that instrument unconstitutional. especially where the circular expressly mandates compliance with internationally accepted legal principles, public policy, and the full observance of human rights, as we showed you earlier. No circular has been invalidated on this basis, nor has it ever been established at the highest level of domestic judiciary that to neutralize means to kill. The judicial record does not sustain such an equation. In each institutional setting, therefore, the term has been situated within ordinary policing powers and constrained by the lawful use of force framework. The testimonies of those operating within that framework, the prosecution's witnesses no less, are aligned with this documentary record. For example, witnesses P1158 and P1170 explained that neutralize means to arrest or to incarcerate through legal means. It did not mean to kill. Witnesses P1050 and P1174 confirmed that lethal force arose only where a suspect's resistance placed an officer's life at risk, reflecting the ordinary doctrine of self-defense and consistent with Mr. Duterte's repeated public declarations that force was justified only in such circumstances. P1214 further indicates that operational decisions were made by officers on the ground within established protocols. So,
Maître, je suis désolée de vous en...
I'm sorry to interrupt, counsel, but once again, you need to be specific and provide the document reference number. You must specify the document number, the reference number for us.
if I may, Madam President,
Merci beaucoup,
of course,
Thank you very much.
an understanding with the Learned Chamber's legal officers that we would be able to provide references after the hearing. But of course, the document that I was referring to is PHL OTP 00090518-R01. So, Madam President, Your Honours, taken together, the manual, the public clarifications by police leadership, the state's position before the highest court in the Philippines, and even the prosecution's own corroborative witness testimony, all of this material demonstrates a coherent and consistent understanding that neutralization was articulated as lawful incapacitation through arrest and related measures, not as a policy of killing. And if the prosecution's case for the common plan in counts 2 and 3 is based on Command Circular number 16 of 2016, we might as well pack up and go home because Mr. Duterte is simply not guilty. However, for the sake of completeness, I continue. The fifth indicator of a common criminal plan, as alleged by the prosecution in paragraph 28 of the pre-confirmation brief, appears to be the concerted broadcasting of inflammatory speech. Here the prosecution once again selectively cites excerpts from 2016 media interviews with Ronald De La Rosa, Bato, and Vitaliano Aguirre, which suit its purpose and case theory, while totally ignoring the more unequivocal comments in those interviews which destroy its case. Regarding the interview with De La Rosa, mentioned in paragraph 28, after supposedly inciting a crowd of drug addicts to cause criminal damage to the properties of their narcotics suppliers, the newly elected chief of police states, "It's either you will die from police gunfire," and he adds, "if you resist." That's PHL OTP 0000849, page 2. Likewise, with the comments in an Al Jazeera interview, PHL OTP 00090340, comments attributed to Aguirre, from which the prosecution imputes criminality to Rodrigo Duterte by citing Aguirre's comment that the administration's policy was to stop crime and kill drug lords. Such throwaway comments reflect on Aguirre alone. And God forbid we're not alleging that Aguirre did anything wrong. Especially when, in the very same Al Jazeera interview, Aguirre states, not once, but twice, that the policy of Duterte himself was for the police to use lethal force only in self-defense. We can display that on the screen, and the part that I want to read is highlighted. And President Duterte was very clear on this matter, he said, Aguirre, that there will be no killing of unarmed offenders, meaning to say that you use force only when your life is in danger. Later on, in the very same interview, Aguirre would repeat the same theme which exculpates Mr. Duterte, PHL OTP 00090340 at page 4. And I read out the relevant passage which is highlighted once again. They are supposed to arrest them, but when they fight back, then the president has instructed them that they must first protect themselves. So much for Mr. Jeremy's elastic mouth theory. Even he thought that Duterte's speech was bifurcated, and even if he did think so, his so-called perpetrators did not. So why does the prosecution cite the excerpts which support its case so selectively? Well, I'm not going to impute any malfeasance, but I can hazard a wild guess. I would suggest that the people reviewing the prosecution's massive databases for suitable evidence are performing keyword searches. Most likely, some of the most utilized operands were the words kill and perhaps sometimes neutralization or neutralize. Once the member of the prosecutor's staff has his hit, he excises the excerpt, rejoices that he can slot it into the predetermined case theory, and does not bother to read the rest of the item of the evidence, where the exonerating evidence is unequivocal. Turning to the sixth indicator of the supposed criminal plan, as set out in paragraph 29 of the pre-confirmation brief. None of the speeches imputed to the former president, nor the use of what the prosecution calls dehumanizing language, dehumanizing language by the alleged co-perpetrators suggests criminality. I would suggest that it is within the bounds of acceptable, albeit extreme political discourse, to refer to drug users in such a way as beasts, animals, or to the barangays as being plagued by the drug menace. Well, the last one is true. You can hardly expect populist politicians and law enforcement officers to refer to drug pushers and criminals as upstanding pillars of the local community. I really do feel that the prosecution is at a loss if this is its circumstantial evidence for proving the existence of a common criminal plan. The same goes for the seventh supposed indicator of criminality, which is based on the names created for the two police operations Double Barrel and Tokhang, along with their supposed evocation of firearms metaphors. While the source for this particular gem, witness P1207, a self-confessed murderous villain, might have guns perpetually on his mind and insert their imagery into his daily speech, it does not mean that those who formulated the anti-drugs policy were acting under a similar caprice when they devised the nomenclature for these two particular police operations. And of course, there were other police operations with completely different imagery, such as the one-time, big-time operation referred to by a few prosecution witnesses, and the riding in tandem operation. The mind can only boggle as to what type of nefarious imagery the prosecution believes that last title evokes. None of the indicators I have mentioned up until now have shown in any way a mutual meeting of minds between alleged co-perpetrators, evincing a communality of purpose or an agreement to act in an illegal fashion. Of course, the prosecution has shown us pictures of the alleged co-perpetrators uttering comments similar to those issuing from Rodrigo Duterte. But this does not indicate a meeting of minds, as I will elaborate shortly. The eighth factor, purportedly evincing a plan of agreed criminality, is set out
naputol na naman po mga kaibigan. Nawala na naman po ng transmission, no broadcast. Anong nangyari? Talagang pinuputol po nila si defense. Talagang makikita nyo mga kaibigan yung pagkakaiba po, dahil yung sa prosecution never po talagang naputol. Kahit panoorin nyo yung prosecution mga kaibigan, yung mga unang araw, di ba? Hindi po napuputol. Pati yung pangalawang araw guys, hindi napuputol. Hindi napuputol yung broadcast nila. Pero dito kay Attorney Nicholas Kaufman, madalas napuputol. Pati yung unang araw napuputol din siya. Ngayon naman ito, pang ilang putol na to, pangalawa na yata, no? So nakita nyo mga kaibigan, talagang may something talaga, no? Tuloy-tuloy po sila pero tayo putol. Ibig sabihin, ayaw nilang ipanood, ayaw nilang iparinig sa atin. Siyempre doon sa ICC, tuloy-tuloy lang yun. Doon, kasi hearing yun eh. Pero pagdating sa broadcast, putol. Ibig sabihin, ayaw nila ipakita sa buong mundo. Kasi siyempre mga kaibigan, live telecast po ito eh. No, ikatatlo na no, pangatlo na po ito, Hello Kitty, di ba? Di ba? Nakakapagtaka lang po mga kaibigan.
Or solidarity of intent, as would be required for a common criminal plan. Or a common plan. Concerning and coming to the 9th category of circumstantial proof for a common criminal plan, the prosecution relies on what it believes to be the Duterte's administration's unabashed publication of statistics recording the number of deaths occasioned in the context of the so-called war on drugs. But let us just look at how and where the statistics relied upon were being published. In 2 government reports, the first of which being the Duterte administration's year-end report for 2017, totaling 63 pages, covering every sector of government and the economy, and of which just 2 pages are devoted to policing activities. We can give you the document ID number shortly. It's on the screen. While the deaths of 3,967 drug personalities mentioned are indeed recorded, as Ms. Robin Croft so helpfully pointed out in her presentation, and are not insubstantial, these deaths comprise a fraction of the 118,287 total arrests for drug-related activities, especially when the government is conducting special operations in a concerted drive to curb the narcotics problem. Such statistics are certainly not indicative of a wholesale policy of murder designed to supplant the process of law. If they were, then certain Latin American state parties would have regularly equaled or exceeded the Philippines in the number of law enforcement killings per capita of the population. What is quite egregious, however, regarding the prosecution's reliance on the 2017 Key Achievement Report is the way in which it glosses over, or rather ignores, those pages which do not suit its case theory. Take, for example, pages 28 of the document, which highlights the fact that 1,900 drug-related investigations had been carried out against law enforcement officers in the preceding year, with 375 police officers being dismissed, including the 2 policemen involved in the murder of Carl Arnaiz, who were later convicted and sentenced to life imprisonment. These policemen were affiliated with the Caloocan City Police Station, and where, so the report mentions, 1,000 personnel belonging to that station were sent for retraining. To conclude, this document, far from being evidence of a conspiracy hatched between co-perpetrators, is in fact a testament to the Duterte administration's respect for the rule of law, unwritten proof of its intolerance for rotten apple police officers. As for the second official publication, which is supposed to substantiate the criminal plan, we turn to the 2016 annual report issued by the Philippine National Police. The statistics are quoted, with all respect, in a misleading fashion. The tables used by De La Rosa, and particularly the pie chart, show a remarkably low incidence of deaths in comparison to arrests and voluntary surrenders. Obviously, the misleading aspect of that is the prosecution's representation of the statistics, not De La Rosa's. So, coming to the 10th and final source of circumstantial evidence, supposedly supporting the mutually agreed nature of the criminal plan. And this is the fact that the extrajudicial killings, to quote the prosecution's words, followed the same patterns and modus operandi, with the perpetrators covering their tracks. But here, let me ask a question, which begs an answer. If the Duterte administration was so barefaced as to openly declare its intent to kill drug users and pushers and celebrate this, as the prosecution argues, in official governmental publications, why would it encourage the perpetrators to go to such lengths to disguise such an intent? I mean, of course, anything's possible. But I'm just pointing out the internal contradiction in the prosecution's case theory. In any event, as they say in English, there is more than one way to skin a cat. And the differing types of modus operandi that we have encountered in the prosecution's 49 incidents of murder involve all conceivable modes of butchery, ranging from strangulation, suffocation, to stabbing and shooting. Now, assuming that the prosecution can overcome the hurdle of proving the existence of a common criminal plan, how has it shown that the so-called co-perpetrators coordinated between themselves to reach a mutual agreement to execute it? Well, it hasn't. All it can do is show a selection of comments made by Mr. Duterte's closest colleagues in government, and all of which take their rhetorical cue from him. The prosecution then artificially defines the intended individuals, the identified individuals, as a collective of co-perpetrators. Now, common law jurisdictions, such as the one I come from, are familiar with these issues in the context of the law of conspiracy. The federal rules in the United States, for example, allow the statements of co-perpetrators to be used as circumstantial evidence, one against the other, to establish the existence of a conspiracy, but require that these statements be made during and in furtherance thereof. Narrative venting, which is what all these supposed co-perpetrators did, the ones identified by the prosecution, does not further the criminal objective. In furtherance thereof means that the statement relied on must advance the objectives of the conspiracy, such as through reassurances, updates, or actions taken to avoid detection. Now, I do realize, Your Honours, that there isn't too much jurisprudence on this matter, but let us look at it logically. Where can one really draw the line if it is sufficient to infer a mutual agreement to execute a criminal plan if we rely only on the statements of the people in the vicinity of a criminally verbose suspect because of the same quality of verbosity it alleges? This is what could be called bootstrapping logic. Building on limited information with the very same information in an attempt to validate that information or to create a structure there without. Put simply, the prosecution has advanced its cart before its horse. It has merely selected a number of individuals working alongside the former president who made similarly offensive comments and has then called them co-perpetrators. Instead of seeking evidence which might shed light on the interactions of these individuals between one and another and construing a criminal conspiracy therefrom, should the evidence even support such a hypothesis, the prosecution has taken its preconceived and predetermined premise of a criminal plan and forcibly superimposed it on these individuals. The artifice of the prosecution's working methodology in conjuring up this criminal collusion becomes even more apparent if we examine the evidence emanating from the crime-based perpetrators themselves on a granular level, especially from the prosecution's own star witnesses, 2 of 3 of whom supposedly formed the hardcore of a more limited organization referred to earlier in my submissions. I'm trying to comply with redactions. P1, for example, a self-confessed murderer whose recruitment by the prosecution will be examined elsewhere, was asked about the common criminal plan of his associates up to 2017. And this is what he had to say. Every time somebody was at fault against the government of Rodrigo Duterte, we didn't bother to send them to prison. We would just kill them. That's PHL OTP 0001-2584 at lines 248 to 250. Okay, and that was the audio which I just quoted, and here we have the transcript. PHL OTP 0001-2376 -R02, lines 248 to 250. So, having given you that quote from P1, I would say that as far as this witness was concerned, the common plan was not a refined policy of cleaning up the streets, but rather a killing frenzy of the political opposition. Obviously, no such policy existed, and no such policy is alleged. P3, whose evidence relates to the presidential period, describes a similar orgy of killing without rhyme and without reason, but not drug addicts, nor alleged criminals, but rather
naputol na naman! Disconnected na naman po sila, mga kaibigan. Ano to? Parang may recess, no? Sabi ni Adele. Sinabutahin nila. Oo, palagi nilang ganito. Alam mo, nagtataka na talaga ako palagi na lang po siyang pinuputol po, no? Samantalang yung mga prosecutor, wala naman talagang cut. Simulat sa poll, hindi po nag-cut ang mga prosecutors. Pero kay Nicholas Kaufman, ako, pang-apat na yata to. Hello Kitty. Pang-apat na po yata to itong pag-cut off nila dito sa sa pagbabasa po ng defense natin na si Attorney Nicholas Kaufman. Kasi talagang na-emphasize niya lahat no? O nga, ginugurgur po nila Luciana Perez, Lulu Opti. Yan no. Opo. Talagang meron talagang something to guys May kasi parang ang dating po, ito ko lang no, ito lang po yung napansin ko. Na bawat, sabi po ni Michael Agzulio, feeling ko may mga copy na yung mga nasa camera na yan. Tapos kinakat pag critical yung dinidiscuss niya. Opo, tama po kayo Michael Agzulio. Yan din po yung ko. Parang yan din yung suspetsa ko. Na parang every time po na ang pinag-uusapan po or yung pag na-critical na po yung topic, piniputol nila kasi limited lang po yung oras dito mga kaibigan Tagi-isang oras lang yata to O tingnan nyo tingnan mo, magbe-break time na naman yan. Pag nag-break time po ito, wala na. Yun na yung pinakahuli. Diba? Opo, talagang pinuputol kasi talagang yung mga prosecutor, wala talagang putol yun. Kahit panoorin nyo, ulitin nyo yung mga nakarang araw, yung first tsaka pangalawang araw. Opo, Elsa Alejandrea. Opo, pag nasoplak sila, no? Yan din tingin ko, pag nasoplak po, pinuputol. Diba? Marilyn Calleja, ayan, no? Omar Lapina, maleta kasi. Basta mga kaibigan, wag po kayo mag-expect masyado, guys, no? Wag po kayo magbigay ng great expectations kasi alam naman natin, iba pa rin ang patakaran dyan po sa ICC. Kasi ang question dyan, kumbaga guys, iniisip pa rin nila yung existence nila, no? Kung magpapatuloy pa ba ang ICC or magsasarado na ang ICC. Parang ganun yan Kaya wag po tayo mag-expect wag tayo masyadong mag-expect. Kung ano po yung mga magiging decision nila dito. Kasi kung hindi ako nagkakamali, itong kaso po ng ating dating Pangulong Duterte, guys, nakasalalay po dito ang survival ng ICC. Kung ano po ang magiging resulta dito, guys, either negative or positive, talagang para po ito makasurvive ang ICC. Kasi critical na po ngayon yung critical na po ngayon ang buhay ng ICC dahil sanction nga sila, di ba? Under sanction sila ngayon ng Amerika. Tapos mayroon din pong mga warrant of arrest. Itong mga ICC judges na anytime po, dadamputin po sila ng mga Ruso. No? Nakalagay po yan sa balita, di ba? Na anytime po mga kaibigan, pwede po silang damputin at pwede po silang kidnapin din, no? Dalhin sila sa Russia para ikulong. So, nasa critical times talaga ngayon ang International Criminal Court. Kaya malamang sa malamang ang magiging desisyon po dito mga kaibigan, either sang-ayon po sa kanilang mga survival or ewan ko lang kung talagang papayagan po nilang pakawalan ang ating dating Pangulong Duterte. Kaya nga sabi ko sa inyo guys, mahirap dito magbigay ng high hopes, no? Kasi pwede po tayong madismaya Kasi kita nyo naman, no? Dito pa lang sa hearing po, talagang pinuputol po nila. Alam naman nila guys na nakatutok po ang buong mundo. Di ba? Buong mundo ito hindi po ito hindi po ito sa Pilipinas lang. Di ba? International po ito guys. Naka-live streaming po ito sa mga iba't ibang mga international community. Lalong-lalo na po sa Amerika, malamang napapanood din to doon. Siyempre, Amerika pa. Di ba? Dito nila masusukat.
Was so petrified at not meeting this quota of slaughter that he was randomly grabbing and killing just so that there would be something to report on TV for the one-time, big-time operation. Now, I ask you, how can P3 have been operating under a clear criminal direction to target drug users for murder, criminals for murder, when he states that on occasion he would perform so-called clean arrests? Prosecution's witness, P3. He's not clear when he's actually following their supposed criminal theory or when he's is. What are clean arrests? These are arrests subsequent to which the apprehended criminal would be handed over for a judicial process. And so with that, I believe, I have exhausted the first limb of the objective requirement for indirect co-perpetration and have shown conclusively that there was no mutually agreed common criminal plan. Madam President, there are 10 minutes to go. I will start with the concept of essential contribution, which is indeed the second limb that I want to talk about with respect to this mode of liability, which requires the prosecution to show objectively that Mr. Duterte himself made an essential contribution to the furtherance of this scheme of criminality, and what is more, that subjectively he was aware that he was making such a contribution. This is what us Latin-speaking lawyers, would call the sine qua non test. Or to put it another way, did these 49 murders, which the prosecution has identified, occur specifically because of Rodrigo Duterte's involvement? Or, to make the logic a whole lot simpler, would Rodrigo Duterte's withdrawal from this criminal scheme to target suspected criminals, as alleged by the prosecution, have led to the avoidance of these 78 deaths? Let us see where this test is set out in the Ali Khoshaib trial judgment. Paragraph 796. And I'm going to quote the essential part for the purpose of the essential contribution. The accused must make an essential contribution without which the commission of the offence would not be possible. To hold an accused liable as a co-perpetrator under Article 25(3)(a) of the statute, it has to be established inter alia that he or she had control over the crime by virtue of his or her essential contribution to it and the resulting power to frustrate its commission. Well, here I would like to show you the statistics pertaining to the rate of killings since the former president has left power and the responsibility for law and order has passed into the hands of President Ferdinand Marcos Jr. I rely on a report published by academics at the Third World Studies Center in the University of the Philippines in the context of what is called the Dahas Project. And trust me, the authors of this report, comprising weekly statistics on the first year of the Marcos administration from 2022 to 2023, are no great friends of the former president, Mr. Duterte. This report was even cited, I remember, in a Rappler article, but it's to be found on our list of evidence at PHL D36 0006-0001, pages 0006 to 0010. The report for the first year of the Marcos administration showed that out of 342 killings, 160 were at the hands of state agents. And the figures and the statistics just kept on rising, with the second year of the Marcos administration, 2023 to 2024, showing an increase in deaths at the hands of vigilantes, albeit a decrease in deaths at the hands of law enforcement officers, from 46.8% to 34%. Hardly a statistic to be proud of. So, with all the prosecutions, fancy bar charts, I'm pretty sure that if they were to recreate them for the period of 2 years after Duterte left power, they wouldn't have room left on their computer screen. The numbers would be so sky high. The conclusion is that there is no reason to believe that Duterte's disappearance from the political scene would have frustrated the ongoing incidents of murder at the hands of state agents or vigilantes. Clearly, I'm forced to ask myself whether anyone on the other side of this room has thought of investigating the Marcos regime and the related phenomenon and holding someone accountable. Why are my colleagues sitting to their right, the victims' representatives, not clamoring for accountability for those deaths? Or is it of no consequence now that Mr. Duterte is sitting in the ICC detention center? I've reached a natural break, Madam President, in my submission. With your permission, I would like to continue after lunch.
Judge Motok. Thank you very much, Mr. Kaufman. We will suspend the hearing now for 90 minutes to resume at 2 p.m. Thank you very much.
Ayan po mga kaibigan. Ikukulong din daw, no? Kung ganun lang ang paliwanag po ni Attorney Nicholas Kaufman, mga kaibigan, kung ganun po ang ginagawa nila kay Pangulong Duterte, dahil siya po ay naging Pangulo, ganun din ang gagawin. Ha? Dapat ganun din ang gagawin kay Kay PBBM. 'Di ba? Sabi niya dapat ikulong din siya. Kasi tumataas din yung krimen. Tumataas din yung mga napaslang na mga otoridad o kaya under the state, no, or under na mga vigilante. Kasi ngayon ang dami din ngayon, ha? Ang dami din ngayon mga bigla-bigla na lang pong natutumba, mga kaibigan, no? Pinapatumba. 'Di ba? Na mga riding in tandem. So ibig sabihin, ang conclusion po ni Attorney Nicholas Kaufman, hindi lang po sa panahon, hindi lang po sa panahon ni Tatay Digong na nangyayari po ang mga ganyan pong mga pagpaslang. Pati po itong present na administration. Sabi nga ni Attorney Nicholas Kaufman, mas marami pa nga daw eh. Kung tutuusin daw, baka daw hindi daw magkasya sa computer. Di ba? So, may relevant. Sabagay, example lang naman yon, di ba? Ibig sabihin, mga kaibigan, kung talagang ganun pala ang turing ninyo sa isang mabuting presidente katulad po ang ating dating Pangulong Duterte, na wala naman siyang ibang ginawa kung hindi protektahan ang mga Pilipino. 'Di ba? Protektahan tayo, protektahan ang state, protektahan ang mga tao para dito sa mga masasamang elemento na naggalat po sa buong ibang sulok ng Pilipinas. Matitigas ang ulo, ayaw tumigil. Ayan, tinakot sila. Yun, tumigil. Nawala yung mga droga, nawala yung mga masasamang elemento. Yung iba nagtago, yung iba nag-abroad, yung iba namayapa. So, napakaganda po ng sinabi ni Attorney Nicholas Kaufman. May resemblance. Ibig sabihin, dapat din pala itong si BBM, itong si Marcos Jr., dapat din pala siyang kasuhan. Sabi nga niya dun sa ano, di ba? Sabi niya, kakasuhan nyo rin to. Malamang sa malamang, kakasuhan nyo rin siya. Kasi pareho po ang nangyari. Dahil po, sabi nga ni Attorney Nicholas Kaufman, nasa third world po tayo. Mahirap po ang Pilipinas dahil sa korupsyon. Di ba? Talagang mayroong ganon. Mga ipinagbabawal na gamot, paano mo pahihintuin yan? Sabi nga niya, iinday-indayon lang daw, no? Kung sa Bisaya pa, inday-inday ba? Hindi pwedeng inday-inday eh. Kailangan mo silang takutin. Kailangan mong mag-exert ng kamay na bakal. 'Di ba? Kasi klarong-klaro naman po ang sinasabi ni Attorney Nicholas Kaufman, pati yung mga nadamay na mga co-perpetrators katulad po ni Senator Bato de la Rosa at si Aguirre, in example din niya. 'Di ba? Kasi hindi naman pwedeng mag-speech ka tapos sasabihin mo sa kanila. Kumbaga parang ang dating mo mga kaibigan, sasabihin mo, pasensya na kayo ha. Mga dorogista, pasensya na kayo ha, hulihin ko kayo. Hindi naman pwedeng ganun. Kailangan mag-exert ka ng effort. Siyempre, takutin mo sila. Kung pwede, pagbantaan mo sila. Sige, huwag kayong tumigil, ubos kayong lahat. Ganun yan eh. Pero hindi po nalalayo sa ginagawa ngayon ni Bangag. Dahil iba yung kay Bangag eh. Wala siyang ganun eh. Pero ang dami pong napapaslang araw-araw. Dahil po naglaganap ang ipinagbabawal na gamot. Ibig sabihin, mas matindi pa ang kaso niya dapat. Mas matindi pa. Kung meron pang mas matindi sa crimes against humanity, itong si Bongbong Marcos, dapat makasuhan pa siya doon na mas matindi pa dyan. Dahil wala siyang ginawa. Hinayaan lang niya. Di ba? Tama si Attorney Nicholas Kaufman. Kaya bravo! Bravo, Attorney. Ang galing mo. Di ba? Yan ang sinasabi natin, guys. Pero syempre mga kaibigan, kahit gaano po kaganda ang mga sinasabi ni Attorney Nicholas Kaufman, magdasal pa rin po tayo. Dahil still, the decision, the final verdict still lies, di ba, with these judges ng ICC po mga kaibigan. Hindi po ito madali, guys. Hindi po ito yung basta-basta na lang na tatanggapin po nila. Alam natin na talagang, ewan ko po kung kailan po sila magbibigay ng verdict. Siguro mag-aantay pa tayo ng mga ilang araw niya, Matagal pa siguro yan bago ilabas yung pinaka-result, Pero bukas po, meron pa po silang final. Hanggang bukas lang kasi ito, And then, hindi ko lang alam kung kailan po talaga magre-release ng final verdict, Baka siguro next month or hindi natin alam, Basta abangan po natin, baka siguro bukas kaagad. Baka bukas kaagad magbibigay na sila ng result. Masaya. 'Di ba? Pero syempre mahirap magsaya pag hindi pa talaga natin naririnig ang sasabihin po ng ICC na not confirmed, FPRD, sabi nga ni Attorney Nicholas Kaufman, not guilty. Yun po ang hatol ng ating defense. Si Pangulong Duterte, dahil wala namang direct implication, wala namang talagang yung masasabi mo na meron po talaga silang mga solid evidence na makapagpaturo po, Kasi lahat sinabi na niya Lahat ng mga sinabi ng prosecutors, sinabi na rin, kinounter po ni Attorney Nicholas Kaufman. At wala naman talagang direct na nagturo sa kanya na si Duterte ang nag-utos. Sabi nga niya, makakapagpakita ba kayo ng direct na evidence na tinuro si Pangulong Duterte na siya ang gumawa? Di ba? Kasi kahit lahat yan, guys, sabihin nyo na lahat. Sabihin nyo na lahat ng masasama sa ating dating Pangulong Duterte. Pero ang tanong ni Attorney Nicholas Kaufman, meron bang isang nagturo sa kanya na ikaw ang pumaslang, ikaw ang gumurgor? Meron ba? Wala, sabi ni Nicholas Kaufman. Zero. As in, walay. Nada. Ibig sabihin, kung wala pong walang direct evidence, walang mga solid or factual na makapagsabi po na si Duterte po talaga ang nag-utos o kaya siya ang gumawa, Duterte po, ang ating dating Pangulong Duterte is not guilty. Ganun lang po kasimple yan. Pero syempre hindi po simple yan, no? Mahirap po yan dahil sabi ko nga sa inyo guys, ulitin ko this is a matter of yung pinaka-decision po mga kaibigan, a matter of survival ng ICC. Kung magpapatuloy pa ba ang ICC or tuluyan na po silang mamaalam. Dahil ito pong kaso ni Pangulong Duterte mga kaibigan, ayon po sa mga abogado, hindi po galing sa akin to. Ito po itong kaso po ni Pangulong Duterte, ito yung parang nagbibigay sa kanila ng buhay. Kasi kung wala po si Duterte dyan sa loob, wala silang sahod. Wala silang pera. Baka nagsara na yung ICC na yan. Dahil po sa sinapit nila ngayon, no? Ito, hindi galing sa akin to, Dahil po sa sinapit nila ngayon, lahat ng kanilang mga bank account, sarado, naka-freeze. Hindi sila pwedeng mag-travel. Hindi sila pwedeng pumutang Amerika. Hindi sila pwedeng gumamit ng kanilang mga cards. Ewan ko lang kung totoo yun, no? Pero, yan po ang nakalagay doon sa sanctions. Diba? So, mga kaibigan, despite po sa mga talagang mga balakid para po masentensyahan si Duterte mga kaibigan na not guilty, alam ko guys, no? May gut feeling po ako mga kaibigan na maganda naman po ang magiging resulta. Pero syempre guys, ayaw ko pong magbigay ng high hopes dahil ako po marami po tayong naririnig at marami din po tayong nakakausap, no, ng mga magagaling din ng mga abogado na talagang ito po ay talagang isusulong nila para mabuhay sila. Sana man lang hindi po sila pupunta doon. Hindi po hahantong doon sa sinabi ko. Dahil pag yun, ang talagang totoo yun, ay nako, wala na po talaga yung pag-asa dyan. Diba? Pero syempre guys, andyan po ang Panginoon. Magdasal po tayo. Huwag po natin kalimutan na manghingi ng enlightenment, no? Na enlightenment ng mga judges, no? I-enlight, no? Bigyan ng magandang desisyon ng mga judges. Sabi ni Hello Kitty, madismaya tadong, just pray. Opo, mag-pray lang po tayo, no? Para hindi po kayo madismaya guys. Para hindi po kayo malungkot. Kasi hindi pa naman natin alam talaga kung anong magiging result nito, no? Mag-pray lang po tayo, no? Tanggapin po natin kung anong mangyayari, no? Yes po, magaling naman po. Sobrang galing naman talaga ni Attorney Kaufman, no? As defense, at least na talagang na-explain naman niya, nabigyan naman niya ng justice yung mga prosecutors, no? Yung mga paratang nila. Nasagot naman niya ng maigi, no? Binigyan naman niya ng counter attack. 'Di ba? Kasi alam naman natin mga kaibigan na itong mga prosecutors po talagang sino ba yung nagsabi nun? Si Attorney Baligod ba yun mga kaibigan na itong mga to si Attorney Delga, sorry. Si Attorney Delga po ang nagsabi na itong mga to wala talaga silang alam sa Pilipinas. itong mga di umanong mga investigador ng ICC, wala naman talaga silang alam sa Pilipinas wala nga silang kilala dito Pero bakit po sila nakakuha ng mga ebidensya, mga documents, mga video na wala man silang kakilala dito? Ibig sabihin, may nag-facilitate, may nag-host. Yun na nga yung lumabas sa pasabog ng mga ex-marines na meron pong involved na nagkabayaran Dahil ginamit po, no? Ginamit po sila para po mga kaibigan makuha yung gusto nila. Kasi kung wala pong collaboration, kasi yan pa ulit-ulit sinasabi ng gobyerno hindi kami nangingialam, wala kami, hindi namin papapasukin ng ICC, hindi namin sila i-accommodate. O, diba? Palagi nilang sinasabi yan. Kahit nga si Robredo, sinabi niya yun. Diba sinabi nila ni Robredo yun? Pero ngayon, tingnan nyo, wala daw, hindi daw nila pinapasok. Yung pala, nakikipag-collaborate pala sila. Diba? Sila pala yung nakikipag-usap. At yun na nga, may kasamang kabayaran. Ayun! Nako, yari. Di umano ha, sabi ko, di umano. Sabi ni Hello Kitty, wrong ka dong, si Triling, o si Jesus Rimulya, o si Delilah. Diba? So, klaro po mga kaibigan, no? Klaro po guys, na talagang ito pong ginagawa ng ICC, hindi naman ito magpa-prosper 'Di ba? Kung walang tulong kung hindi tinulungan 'Di ba? Ito ba lalabas ba itong mga dokumento na to kung walang tumulong sa kanila? Ay, naku, ewan ko lang talaga. BO ka na kung maniniwala ka na walang tumulong. So, ibig sabihin, may tumulong. Kaya nga yung mga ex-Marines, tama po ang kanilang mga salaysay. Bravo sa mga ex-Marines. Saludo po tayo sa kanila. Wait lang ayusin lang po natin mga kaibigan, no? Para dire-diretso po tayo. Baka mag-start na po ito. After 90 minutes ba yun? Ilan bang minutes? Mukhang matagal-tagal pa ito mag-start Ito na po yung last na confirmation of charges po mga kaibigan. Itong araw na to. Babalik po ng after 72 minutes. Babalik po siya 9:25 p.m. Okay? Babalik po tayo ng 9:25 p.m. Kaya, pwede pa kayo magpahinga? Pwede kayong kumain uli. Yung mga hindi pa kumain dyan, pwede kayong kumain. Yung hindi pa nakapag-snack, pwede kayong mag-snack. O yung iba dyan, baka pwede kayong magkape. Okay, matulog muna kayo. Ay, huwag kayong matulog. Baka mamaya, bukas makatulog talaga kayo. Hindi na kayo makapanood. Lunchtime, no? Lunchtime, no? Sabi ni Kitty, mga 2 p.m. pa dong lunchtime. Lunchtime daw ngayon, So, ibig sabihin, kumakain pa sila ngayon, no? So, pahinga muna tayo, mga kaibigan, no? Babalik po tayo ng 9:25 p.m. Okay? Ewan ko lang kung masusunod na naman to. Baka mamaya, 10:00 po ito babalik. Katulad kahapon, ang tagal bumalik, Diba? Ay, nung isang araw pala, no? Wala pala kahapon. Pero talagang pampered nila yung mga prosecutors kahapon, no? Di ba napanood yun naman? Pampered nila, no? Talagang inaasikaso pa nila. Tapos hindi man lang napuputol yung mga connection. Di ba? Pero itong kay Attorney Nicholas Kaufman, mga kaibigan, talagang klarong-klaro po na meron talaga silang kinikilingan. Biruin mo, 4 na beses na putol. Hindi natin alam kung anong pinagsasabi na doon kasi putol na The moment na naputol po yun ng mga ilang minuto, hindi mo na makukuha yung portion na yun. Kasi live po ito, guys. Hindi po ito pre-recorded. Isa po itong live na hearing. Pag naputol, wala na. Goodbye na. Hindi mo na maririnig yun. Lahat tayo, hindi na po natin makukuha kahit anong channel pa yan. Wala po silang ganon. Kasi isa lang po ang source natin, which is the ICC. So, mga kaibigan, masakit mang isipin, guys, no? Antayin na lang po natin kung ano po ang magiging result. For the meantime, konting anong oras na ba? 8:14. So, meron pa tayong ilang oras? Meron pa tayong mga 1 oras. Tagal, 1 oras. Grabe. 1 oras na pahinga. Ibang klase itong hearing na to. 1 oras ang pahinga, Ganun kasi sa ibang bansa, pagkakain talaga sila. Okay? So, mga kaibigan, mag-break time muna tayo, ha? Balik na lang po kayo mamaya. Kung yung iba dyan, baka may mga trabaho pa. Magtrabaho muna kayo. Pero mamaya po, kung wala po kayong gagawin, libre po kayo, no? Wala po kayong trabaho, at pwede po kayo manood, balik na lang kayo. Pero pag may trabaho po kayo, okay lang po kay Foodinet yun. Di bali walang manood, okay lang sa akin kahit walang manood. Basta importante po, makover natin ito guys, para po ito, support na rin po natin ito sa ating dating Pangulong Duterte. Kasi importante po ito guys kasi kailangan natin tumakuha piece by piece, kasi defense na po ito, no? Si Attorney Nicholas Kaufman na po ang nagsasalita. Opo, mahaba talaga ang oras nila, kaya po humahaba yung oras nila kasi ang haba din kasi ng break time. Biruin nyo, tagi-1 oras. Di ba? Kaya humahaba yung oras nila Hindi na nila tinutuloy-tuloy na lang no? Isang tuloy na lang na isang pasadahan na lang para wala ng Kaya lalong humahaba, no? Mas masipag pala ang Pinoy, no, kaysa sa mga sa mga foreigner. Kasi tayo pag nag-hearing tayo dito, doon kumakain sa Ang tawag doon working lunch, no? Doon na sila kumakain sa hearing. Ganong kasipag ang Pinoy, no? So anyway, sa mga suki, ayan si Cat Beach, Sir Foodie, mahaba pa oras ha. Oo nga, mahaba oras So mga kaibigan, magpahinga muna tayong konti. We'll be right back, okay? Music muna tayo. po mga kaibigan, balik na po tayo guys. Andyan na ba kayo? Gising pa ba kayo mga kaibigan? Ito po, balik na po tayo. Magsisimula na po maya-mayang konti po. Konting tiis na lang po guys. At mag-uumpisa na po ang pinakahuling yugto or pinakahuling session po ngayong araw, ang confirmation of charges ng ating dating Pangulong Duterte. Ito na po yung pinaka-last part, no? Medyo talagang matagal po ang kanilang sobrang tagal po ang kanilang break, talagang 1 oras po. Samantala, habang nag-aantay po tayo mga kaibigan, meron po tayong balita dito guys. Alam kong kilala nyo po ito. Mga suki, pasok na po kayo. Andyan na ba yung mga ano natin? Ay, present na pala si Ruthie, oh. Hello, Ruthie. Ayan. Gising pa pala. Sino pang mga gising dyan? Oh, sino pang available dyan? Mag-uumpisa na po tayo, guys. At marami po tayong medyo mahaba-haba pa po itong pinaka-last part po ng confirmation of charges ng ating dating Pangulong Duterte. May mga 1 oras pa po ito mga kaibigan. So, malamang sa malamang matatapos po tayo ng mga 10 p.m. or 11 p.m. Kaya sa mga avid listeners, viewers, subscribers natin dyan, pasok na po kayo. Dahil ito na po yung pinakahuling part ng session. So, umabot po tayo ng almost maglilimang oras na po, no? So, aabutin po ito ng mga 6 hours. Mahigit 6 hours po ito mga kaibigan, itong hearing. Napakahaba ng hearing, pero napakahaba ng break time. Mahaba yung hearing, mahaba din yung break time. Pambihira naman, oh. So ito po, meron po tayong breaking news. May lumabas po kanina guys sa balita na ito pong si Anyo, di ba? Kilala niyo si Anyo? Ano pa si Anyo dati? Ano to no? Duterte to dati, si Anyo Mariing itinanggi ang paratang sa affidavit ng 18 dating sundalo dahil lumabas po ang pangalan mga kaibigan ni Anyo. Naku, ito yata yung traidor Ito yata yung sinasabi nilang traidor mga kaibigan, no? Ewan ko lang Ayan po, oh. Ang nakalagay po dito guys, basahin lang po natin. Hindi ako kailanman dumalo sa anumang pagpupulong kasama sina dating Speaker Martin Romualdez, dating Congressman Zaldico at Congressman Laila de Lima sa Polo Club, Townhouse, sa anumang lugar, at hindi rin ako tumanggap ng anong paper bag or pakete mula sa kanila. Ayan, oh. Nako, ito yata yung sinasabi nilang traidor, Hello, Lalaine Garcia, still awake. Ayan, oh, gising na gising pa si Lalaine. Andito naman si Melissa Restoles. Kasalanan mo yan, di bali magkamali ka naman ng maraming magkamal ka naman ng maraming pera, tama lang, mabuti mga bashers lang kayo ng tao sa dami yung kurakot. Mayaman ang mga anak mo galing sa kurakot. Si Vicky Swai, still watching from Hong Kong, Foodienet. Hello Vicky Swai. Shout out. Sir Foodie, isa ring traidor ng mga Duterte. Opo nga traidor talaga siguro to. Ito yata yung sinasabi nilang ito yata yung sinasabi nilang taksil Ayan, nakaantabay pa rin po ako, Foodie, kasi nasa work pa rin ako. Ayan. Good luck po sa work Vicky Swai ng Hong Kong. Si Charmy Aeon Spot. Ayan. So ito po, basahin lang po natin guys, no? Mariing itinanggi ni Eduardo Anyo, National Security. National Security Advisor pala ito dati. Grabe. At retiradong general ang alegasyon ng tumanggap umano siya ng paper bag matapos sa isang pagpupulong sa Polo Club Townhouse. Ang pangalan ni Anyo ay lumitaw sa pahina 17, item number 49 ng joint affidavit na inuugnay sa 18 dating Marines at sundalo. Sa nasabing bahagi ng dokumento, Nakasaad ang paratang na nakita umano siyang binigyan ng paper bag matapos ang meeting kasama sina dating Speaker Martin Romualdez, Zaldico at Laila de Lima. Nako, grabe. Nakita daw siya, guys, binigyan siya ng supot, no? Paper bag, itong si Anyo. Totoo ba ito, mga kaibigan? Grabe naman po ito, guys. Sa kanyang opisyal na pahayag, tinawag ni Anyo na malicious at walang basihan ang nasabing affidavit. I categorically reject the denounce the malicious unsigned affidavit purportedly from 18 ex-Marines accusing me of receiving a paper bag after meeting at the Polo Club Townhouse. Sabi po ni Anyo. Dagdag pa niya, to set the record straight, I have never attended any meeting with former Speaker Martin Romualdez, former Kong Zaldico, and Kong Laila de Lima in the Polo Club Townhouse or in any other location, nor did I receive any paper bag or package from them. Upang ituwid ang record, hindi ako kailanman dumalo sa anumang pagpupulong kasama sina dating Speaker Martin Romualdez, dating Congressman Zaldico at Kong Laila de Lima at Polo Club Townhouse sa anumang lugar. At hindi rin ako tumanggap ng anumang paper bag. So mga kaibigan, talagang dinideny niya po. Binanggit din ni Anyo na magsasagawa sila ng sariling investigasyon upang alamin ang motibo sa likod ng paglabas ng affidavit, lalo at lumutang ito kasabay ng mga pagdinig kaugnay sa International Criminal Court at iba pang sensitibong issue sa bansa. We will have our own investigation that determine whether this malicious stunt gives this timing amid the ICC hearings, the EDSA anniversary, and the planned one-time big-time mass action is similarly part of the broader effort to undermine or destabilize government institutions. Panawagan sa publiko. Nanawagan si Anyo sa publiko na maging mapanuri at huwag basta magpadala sa mga aligasyon hindi pa napapatunayan. I urge the public to be discerning and not be swayed by misinformation. Rest assured, the government will continue to address legitimate concerns through proper channels and uphold rule of law of all times. Sa kabila ng paglitaw ng kanyang pangalan sa pahina 17 item 49 ng affidavit, nanatiling matatag ang pagtanggi ni Anyo at iginiit na wala siyang kinalaman sa sinasabing cash or paper bag delivery matapos ang umano'y pagpupulong. Nako, todo tanggi po mga kaibigan. Etong si Anyo, nako, baka ito yung sinasabi nilang traidor, ha? Ewan ko lang po mga kaibigan, no? Ito po, ipakita natin yung ano. Ito, ipakita natin yung nakalagay sa affidavit. Ayan, oh. Oh. Kita nyo? Number 49. Nakita rin namin na si Retired General Edward M. Anyo ay binigyan ng isang paper bag pagkatapos ng meeting nila sa Polo Club Townhouse kasama si Zaldico, dating Speaker Martin Romualdez at Laila de Lima. Sos, nako, huling-huli po. Ayan. Nasa ano po ito, ha? Nasa affidavit po ito, guys. Diba? In-explain ko na sa inyo yung affidavit na nakapirma na po at ito po ay notarized na po at ito po ay nasa ombudsman na. Kanina lang po mga kaibigan, dinala sa ombudsman. So ano po itong sinasabi or ano po itong pagdi-deny ni Retired General Anyo? Nako, Duterte pa naman ito? Anong nangyari? Ha? Opo, madali lang po mag-deny, no? Madali lang po mag-deny, guys. Sabi nila Lane, Sir Pudi, deny. Isa siya nagpapadala kay Tatay Digong sa dahig. Kaya nga pa-deny ka pa. Baka siguro ito na yung hinahanap natin na traidor at taksil na sinasabi po or nung isang araw po mga kaibigan na topic po natin dito, no? At nagpasabog po si Attorney Harry Roque na may isang taksil sa kampo ng ating dating Pangulong Duterte. Kasi nakakapagtaka talaga bakit nila nakukuha yung mga information Lalong-lalo na po ang mga confidential documents. Paano po nila iyon nakukuha kung hindi po sila, kung wala po silang personal na or wala po silang hindi po sila close, no, doon sa circle ng mga Duterte. Ibig sabihin, guys, talagang tama yung sinabi ni Attorney Harry Roque, may nagtaksil. Ito, lumabas po ito mga kaibigan sa affidavit ng mga ex-Marines. So, therefore, pwede po natin ito makonclude na maari po talaga mga kaibigan na malamang sa malamang, hindi ko naman sinabi na confirm, no? Ito po yung mga alleged, no? Na ito pong si retired General Anyo ay malamang sa malamang ay ito po siguro yung nagtaksil sa ating dating Pangulong Duterte. Nako, nakakahiya naman yung ganon. Ikaw pa naman yung dating DND, no? Dating DND pala ito ng kapanahunan po ng ating dating Pangulong Duterte. Ngayon, isa na po siya, mga kaibigan, sa talagang nagtaksil. Nako, ewan ko lang talaga kung ano pong gagawin nila dito, guys. Pero sabi nga nila mga kaibigan, hindi lang namang isang tao yan eh. Marami pa pong nagtataksil, no? Marami pa pong mga traidor. Hindi pa lang po nadidistinguish, no? Unti-unti pong lalabas yan eh. Pag talagang nagkakagipitan na po mga kaibigan, malalaman na po natin lahat yan. Di ba? Pero ito po, dito muna tayo mag-umpisa sa mga affidavit ng mga ex-Marines, kasi talagang ito po ay mga sinumpaang salaysay. Hindi po ito basta-basta lang na nagpapakalat po sila ng mga informasyon. Ito po ay talagang permado, notarized, at meron pong mga witness na talagang ito pong affidavit ng mga ex-Marines ay talagang pawang katotohanan lamang mga kaibigan, wala pong halo itong kasinungalingan. Pero syempre guys, sabi nga nila, there's a proper forum para po ito po ay dinig or ito po ay talaga pag-usapan, no? Para malaman talaga natin kung sino ba talaga ang mga traidor sa ating dating Pangulong Duterte. So, abang-abang po tayo guys dahil magkakaroon daw ito ng Senate hearing. Ewan ko lang kung matutuloy ba. Dahil nasa ombudsman na po. Malamang sa malamang aantayin muna nila yung ombudsman, no? Kung ano po ang magiging desisyon or ano po ang magiging investigation ng ombudsman. Baka siguro pag meron na pong nilabas ang ombudsman, baka doon pa lang sila magkakaroon ng Senate hearing. Pero medyo malabo yung dating na gano'n, no? Sana ngayon pa lang, after nitong confirmation of charges, sana sa March magkaroon na po ng hearing. Para at least mga kaibigan, mas maganda kasi yung unahan na nila eh. No? Kasi mamaya, may nagsabi po na isang professor din no? Na baka matulad po ito guys kay Master Sergeant Gutesa. Wag naman sana. Kaya nga ang pinakamagandang suggestion dyan, unahan na nila. Di ba? Pagdating ng March, birahan na kaagad. Di ba? Hearing na kaagad para magkaalaman na. Okay po, malapit na po tayo mag-umpisa guys. Wait lang konti na lang po mga kaibigan. Mag-uumpisa na po itong pinakahuling yugto or pinakahuling session po ngayong araw sa confirmation of charges ng ating dating Pangulong Duterte. Ito na po ang pinakahuling explanation or huling laying of cards from our defense lawyer, Attorney Nicholas Kaufman. At meron pa po tayong pinakahuli din, no? Meron pa tayong hearing bukas, no? Yung hearing bukas, ewan ko lang kung ano po yun. Baka siguro yun na yung verdict. Ewan ko lang kung yun na ba yung result. Pero mukhang iyon po ay parang pinakahuling part po talaga ng itong confirmation of charges. So mga ilang minuto po mga kaibigan ay mag-uumpisa na po tayo. Kaya sa ating mga suki dyan, pasok na po kayo. Ayan, ayan, magandang gabi si Emily. Ayan, Hazel Aquino. Kalat na ang affidavit ng mga 18 Marines. Naka-rating na rin sila sa ICC, ikulong na sila. Or nakarating na. Ayan. Reagan Magaspag, Ombudsman, Sindikato din yan. Boying Rimulya, wala yan. Jennifer Danlayon, si Dizon, at confirm na. Traidor kasi mga nakikita sa talaga ng mga traidoran na ngayon. Si Regan Magaspag. Ayan, magandang gabi po sa iyo, ka Foodinet TV. Good, mabuhay ang lumalaban sa katiwalian ng Administrasyong Bangag. Hazel Aquino, ayan. Si Jennifer Danlayon, duda din ako kay General Galvez. Hazel Aquino, puro deny na lang sila. Puro deny lang talaga ngayon, oh. Jennifer Danlayon, noon pa ako naduda kay Anyo kasi nga siya'y DILG-SEC. Wala naman sila ibang ginawa kundi mag-deny eh. 'Di ba? Lalo na yung mga miyembro ng Tuwadcom, puro deny. 'Di ba? Wala silang ginawa kundi ito na, umpisa na yata. Wait lang po mga kaibigan, mukhang mag-uumpisa na po tayo, guys. Wag sana nila itong putulin, wag sana nila itong ikat.
I'd like to begin with an oral ruling regarding the redactions made to the transcript and direct broadcasting today. The Chamber notes that redactions were made to the transcript and to the direct broadcast of the hearing subsequent to an application by the prosecution and which was opposed by the defense. The application of the requested redactions apparently would be a problem and could lead to hearings being held in closed session. The Chamber wishes to recall an earlier ruling during which the Chamber stressed that it is up to the parties and participants to ensure that their submissions are worded in such a way as to avoid going into closed session, thus ensuring the transparency of the proceedings and to avoid the disclosure of confidential information. The Chamber would remind the parties to comply with these instructions. Furthermore, the Chamber is of the view that the information that was asked to be redacted and also from the direct broadcast today were limited to identifying information of witnesses and victims mentioned during the submissions. The defense disclosed information on several occasions that allowed for the identification of victims and witnesses. For example, positions held and nicknames, things that must not be disclosed so as to ensure the protection of witnesses and victims. The redactions had only to do with identifying information and were not as general, redactions to the events within the case. This was the appropriate recourse to implement the Chamber's duty to protect the safety and well-being, including psychological well-being, the dignity and privacy of victims and witnesses in accordance with Article 68 of the Rome Statute, without having to hold the hearing in private or closed session. Thus, the Chamber has decided to maintain the redactions that were applied earlier and reminds the defense not to disclose information that may not be necessary and information that could identify witnesses and victims in accordance with Article 8 of the Code of Conduct of Council. I thank you very much. And Mr. Kaufman, you may now proceed and continue your submissions on the merits. You have until 3 p.m. Thank you very much.
Thank you, Madam President. As you can see, we have a number of yellow post-its on our table here. These are the document identification numbers of all the matters that I'll be talking about. But since we only have until 3 and until 1 hour tomorrow morning, I can provide the ID number if necessary, but I will move on, and we promise to give the Chamber at the conclusion of the hearing the full ID numbers of everything that I've talked about. And if the prosecution obviously wants something as well, he can...
Afternoon, Madam President. I would just ask my friend if he can read out the tab numbers, because every item per the Chamber's instruction has a tab number. So even if my friend doesn't read out the entire ERN of the page he's citing, the lines, if he gives us a tab number, at least we can check his homework in real time.
Merci beaucoup.
Thank you very much. Counsel, are you in agreement with this position taken by the prosecution? Well, the representative of the OTP. Mr. Kaufman, yes, ma'am. Judge Motek, please proceed.
Come to ask myself another question concerning the nature of a common plan theory which applies equally to its subjective requirements. Has the prosecution shown substantial grounds to believe that Rodrigo Duterte's implementation of its fantasy criminal scheme was of such a nature that the murders detailed in its 49 charged incidents would have ensued as a virtual certainty in the ordinary course of events, and that he foresaw that they would occur as a virtual certainty in the normal course of events? Let us take a moment so that I can assure you that these wonderful words, virtual certainty, actually do exist in the court's case precedent and are not a fiction of my own. If you will, please display the first of 2 citations from the Abdul Rahman, otherwise known as the Ali Kushaib trial judgment from 2025. First of all, paragraph 795. While the common plan between individuals need not be specifically directed at the commission of a crime, it must nevertheless involve a critical element of criminality, meaning that in the context of the specificities of the case, it was virtually certain that the implementation of the common plan would lead to the commission of crimes. We can have a look at paragraph 706, and it talks about the general knowledge requirements, which I am sure Your Honours are very familiar with. So, with respect to the question whether the common plan entailed the occurrence of murders as a virtual certainty, the answer is an emphatic and resounding no. First of all, let us recall what the prosecution defines as the former president's list of high-value targets, what the media calls the kill list, and what one of Mr. Edward Jeremy's quoted witnesses referred to as the dead list. The number of individuals on this so-called kill list, the very list on which the prosecution relies to show that the knowledge that death would ensue, is 4,817. Those who are actually neutralized dwarfs in comparison and stands at 248. So, assuming that neutralized actually means killed, which it does not, then there is no virtual certainty attributable to Rodrigo Duterte that death would ensue from this kill list. Rather, a 5% chance. Let us have a look at a bar chart for exactly the same figures used by the prosecution as distributed geographically. I now turn to the issue of control, as it did or did not manifest itself in the crime base. In other words, can it safely be argued that substantial grounds exist to believe that Mr. Duterte's supposed diktat filtered its way down from his mouth and via his co-perpetrators to those who were supposedly going about committing these murders? How has the prosecution shown the concept of automatic compliance, or even virtually automatic compliance, so essential to its pyramidal structure? Well, by and large, and judging from Ms. Robin Croft's submissions, it would appear that the concept of automatic compliance is substantiated by reference to subjective comments made by perpetrators who talk about their will being controlled. For example, transcript, page 37, line 7 onwards. I felt like that I didn't have any choice but to follow their orders. It wasn't possible not to obey his commands. Another example, transcript, page 38, line 17. Co-perpetrators controlled the will of the physical perpetrators. End quote. According to the prosecution, members of the Davao death squad had to seek clearance from Mr. Duterte to conduct killings in Davao City. For this wild assertion, the prosecution relies once again on the evidence of criminals it has recruited, all of whom are inherently unreliable because of their being self-confessed vicious murderers, testifying in return for virtual immunity from proceedings at the ICC. We shall analyze the testimonies emanating from these individuals in detail later in my submissions. Now I can see Mr. Nichols scribbling away there, but I shall be referring to what are called statements of limited use. As for the other modes of liability charged, ordering under Article 25.3b and Article 25.3c, aiding and abetting, as I have said, no smoking gun, no evidence of a direct order, solicitation, or inducement with respect to any one of the 49 incidents. No documentary record exists of a presidential order. So how could these orders have been transmitted for the purposes of Article 25.3b? Well, unless Mr. Nichols envisages mental telepathy, I think that we can discount ordering. The prosecution has failed to elaborate in its oral submissions what it means truly by soliciting. If it means the ambiguous public speeches, then it is difficult to reconcile the frequent exhortations to self-defense with soliciting, unless, of course, you accept that Mr. Duterte super craftily inserted these exonerating comments into his speeches in order to craft himself a defense when the day of reckoning would come. As the prosecution asserts, speaking with a forked tongue, sometimes speaking his mind, sometimes saying what he wants you, your honours, to hear. Furthermore, generalised statements months before specific incidents do not establish causation or instruction. For aiding and abetting, there is no reliable evidence that Mr. Duterte provided practical assistance, encouragement, or moral support that substantially affected the commission of a crime with knowledge of the perpetrator's intent. And finally, on modes of perpetration, modes of liability, I would beg you not to take heed of Ms. Paulina Masseter's assertion that Rodrigo Duterte failed to prevent or punish. The prosecution has not charged command responsibility under Article 28. And the reasons for that are clear. It is the same reason why it cannot prove ordering. There is no ascertainable chain of command descending from Duterte at the top via the co-perpetrators, so-called co-perpetrators, all the way down to the crime base. As I said, it all breaks down at the level of the co-perpetrators. And I would ask you very respectfully not to exercise your discretion to requalify pursuant to Regulation 55 of the regulations of the court. But if you do, and you shouldn't, I respectfully submit, you should order the prosecution to resubmit its document containing the charges and its pre-confirmation brief as amended, and to release Mr. Duterte in the interim. Now, I have finished that section of my submission, and I will now turn to the witnesses themselves, and I will be very careful not to mention anything that I'm not meant to. And I will discuss, first of all, the general reliability. A genuine criminal investigation is meant to be directed at establishing the truth. It is meant to elicit facts in an impartial manner and not to present witnesses with a preconceived idea and to seek confirmation thereof, whether it be by way of leading questions or anything else. By this, I mean that the golden thread linking practically every one of the interviews of the prosecution's so-called insider witnesses, who are, for the most part, ruthless criminals, is the a priori targeting of Rodrigo Duterte. In my submission, no real attempt was made to perform this duty of examining exonerating circumstances, or even to establish the existence of other actors who might be responsible for the high incidence of deaths in the context of the war on drugs. Most prosecutors will collate the evidence and thereafter analyze it and decide whether to prosecute with a view to obtaining a reasonable prospect of conviction, which is indeed the standard supposedly applied since Mr. Karim Khan assumed the role of chief prosecutor. A prosecutor is not meant to choose his target in advance and then find the evidence to support a preconceived desire. Now, I'm not going to engage upon a wholesale forensic analysis of the credibility of each and every witness. I am long enough in the tooth to appreciate that issues of credibility and weight are not normally litigated at confirmation, but are left to trial. This case, however, is unique. And as I have said, the prosecution's star witnesses are self-confessed murderers. And most of their statements were taken by the prosecution's investigators with the assurance of limited use, namely that anything self-incriminating would not be used against them in proceedings at the ICC. Although Mr. Nichols will undoubtedly tell you that these agreements of limited use are not to be understood as the grant of immunity from prosecution, for all intents and purposes, they are. And I am prepared to wager that we will not see even one, not one, of these incriminating witnesses in a dock at this court, nor in a dock at any court anywhere in the world, after they have been rehoused and given protection at considerable expense to the state parties funding this court. I do not think that I would be alone either in believing that there is something morally repugnant or even questionable from a public policy standpoint to shield not only one, but a number of murderers from prosecution at the ICC just in an attempt to nail Rodrigo Duterte. Indeed, in many common law jurisdictions, the use of a self-avowed murderer to convict an alleged murderer would normally entail vetting and scrutiny of the highest order. Those words, if I'm not mistaken, come from the Crown Prosecution Service's instruction manual. Public source. In fact, I would suggest that it would normally only be approved, firstly, when it is considered of more value to have a suspected person as a witness than as a possible accused. Secondly, whether obtaining the conviction of an alleged murderer is more important than the release of a self-confessed murderer. And finally, whether it is likely that a conviction could be obtained without the cooperation of the self-confessed murderer, or a number of them. Even after this vetting process, most courts in common law jurisdictions require an evidentiary supplement before relying on the sole testimony of a cooperating criminal witness, or what is otherwise called an accomplice witness. Such an evidentiary supplement in legal parlance is called corroboration, and rules exist governing what may be deemed suitable corroboration. I'm pretty sure that these considerations were never considered by the prosecution, for one very simple reason. At least two of the most prominent accomplice witnesses were offered up to the prosecution on a silver platter, and I cannot say by who in open session. Neither the Rome Statute nor its accompanying texts regulate the way statements of limited use are employed. I would like the pretrial chamber to consider the way academics and the prosecution itself has qualified the implementation of limited use statements in the past. And I quote from paragraph 49, which is open source, of a chapter on the Office of the Prosecutor in the 2022 edition of the Max Planck Encyclopedia of International Law, written by no less than Judge Betty Hola of this court. And I quote, "One of the agreements the OTP may enter into during the investigation is an agreement with a person suspected of committing crimes within the jurisdiction of the court, is to provide a statement of limited use. The idea is that the person provides the Office of the Prosecutor with an oral or written statement for the purpose of pursuing leads or developing additional information or evidence on the condition that the statement will not be used against the interviewed person except as stipulated in the agreement. The purpose of such agreements is to ensure cooperation of so-called insider witnesses whom the OTP does not intend to prosecute, but are expected to provide key information or evidence against other, usually more senior suspects. Judge Höhler was effectively relying on footnote 20 to the prosecution's own filing, number 1118, in the Bemba Article 70 case, which states the same thing. Both sources stressed that limited use statements should be used as a rule to pursue leads or to develop information, but not apparently, outright at any rate, to serve as the key and main testimony against a suspect. In my opinion, there is a good reason for this, and it is contained in the wording of Article 54, 3d of the Rome Statute, which is cited as the statutory basis for limited use statements. The prosecutor is entitled to enter into such agreements granting limited use on condition that the agreement would not be inconsistent with the statute. And I stress those words, not inconsistent with the statute. Using the evidence of self-confessed murderers to obtain leads or develop evidence from other sources, I would suggest, is consistent with the statute, as mentioned by Judge Betty Höhler. To give a get-out-of-jail card, however, to a whole bunch of murderers in order to fix liability to another, albeit pre-selected individual, also selected of murder, is, in my opinion, totally and wholly inconsistent with the object and purpose of the Rome Statute, which, according to its preamble, oft cited by the victims and the prosecution, is dedicated to the eradication of impunity. In my opinion, granting immunity to a murder suspect for core international crimes would be seen as undermining the object and purpose of the Rome Statute. Accordingly, I would ask the Chamber to find the statements of those witnesses afforded such limited use and to be of negligible evidentiary weight. Another issue pertaining to the general credibility of the prosecution's witnesses is the way in which they were recruited. In my opening remarks a couple of days ago, I talked about the general fairness of pursuing charges brought by a prosecutor who was formerly a representative for more than 100 victims of Mr. Duterte's alleged crimes. I also talked about a recorded telephone conversation in which one of the participants bragged about acting as President Marcos Jr.'s silent partner for channeling witnesses to the ICC. Apparently, I raised the presidential spokesperson's hackles considerably. So let me quote a bit more so that I can assure her that my cognitive faculties, which she doubted, are in fact intact. And this is what this covertly recorded individual, who I'm forbidden from naming, said. "They cooperate through me, since I don't hold a position. Redacted. But we are able to do it. So what? What happened here is an ICC investigator will give me a list of witnesses, documents they need to bolster the case against Duterte. Then I provide it. I give it to the different agencies so it can be approved. There are witnesses who need a pardon. I get the authority from the president, and they are granted a pardon. Basically, like that, it becomes a priority mission of the government. I don't think I've disclosed here, Madam President, any working methodology of the Office of the Prosecutor. So now I turn to the incidents themselves, the 49 incidents. The prosecution invites you to view these incidents as the manifestation of a much larger pattern. To quote the prosecution's very words in filing number 330 at paragraph 5, the 49 incidents are a non-exhaustive list of examples of the conduct underlying the charges. Indeed, the prosecution speaks of thousands of victims in toto, data sets, and patterns of violence. Now, the defense does not deny that much drug-related violence did occur. It was occurring before Mr. Duterte assumed the reins of power and continued, as we have shown, by way of a sharp increase after he left office. But these grandiose visions of the prosecution are of no avail if the core criminality and incidents alleged in its document containing the charges are not made out. So the question before you is whether there are substantial grounds to believe, firstly, that each of these specific incidents were unlawful killings, namely, deliberate acts of murder, and secondly, that they were knowingly committed to further the criminal objective of the so-called common plan or the state organizational policy with which it has been conflated, and finally, that they are indeed attributable to Mr. Duterte under a recognized mode of liability. Preempting a possible defense, always a good tactic for a prosecutor, unsure of the strength of his own case, there is a heavy reliance on expert analysis of data sets to argue that reported instances of self-defense were statistically improbable. Let me stress that it is the defense's view that if the contextual case depends on the scale of victims, namely thousands, as alleged by the prosecution, then establishing the evidentiary integrity of each charged incident is imperative. In other words, the defense firmly submits that the pretrial chamber should not commit any one of the 49 incidents to trial unless it concludes that there are substantial grounds to believe that Mr. Duterte's criminal linkage and liability has been established for each one. When these 49 incidents are disaggregated and examined one by one, as the statute requires, we submit, what becomes apparent is not the cumulative strength, rather the recurrence of certain symptoms of inherent weakness in the evidence. These weaknesses fall into 6 broad categories. The first is the over-heavy reliance on the testimony of cooperating witnesses who are inherent criminals with an inherent propensity to be unreliable and whose statements as I mentioned, are not corroborated by external evidence. The second, hearsay attribution, or in less legal parlance, incriminating statements heard from a source twice or even 3 times removed. The third weakness, which infects the evidence, is the fact that some of the victims are unidentified, making it virtually impossible for the defense to pursue its own lines of inquiry. This weakness affects at least 9 out of the 49 incidents. The fourth weakness, documentary records, such as police and forensic reports, are at variance with and are contradicted by testimony of a single prosecution witness. Fifth, the hoary old chestnut of conflicting statements emanating from 2 or more witnesses testifying to the same event, some contradicting one another, some contradicting even themselves. And finally, the sixth weakness being the repeated absence of any evidence to link the hitmen to our client, despite the prosecution's best efforts to chivvy such linkage out of them. The defense will now show how these identified weaknesses reduce below the substantial grounds threshold the evidence for these incidents in the 3 counts as they appear in the document containing the charges. Count 1, the alleged murders during the mayoral period. Count 2, alleged murders of HVTs, the high-value targets, during the presidential period. And count 3, barangay clearance operations also during the presidential period. So I shall start with count 1. As we know, the first cluster of incidents falling under count 1 concerns the so-called and totally fictitious Davao death squad period. This concerns incidents 1 through 9 of the document containing the charges. The prosecution's attribution theory here is straightforward, that Rodrigo Duterte, as mayor, authorized killings through intermediaries. But when the evidence for this count is examined, as I've already mentioned, not one witness can say that he heard the mayor give an order to kill. The attribution of criminality to Mr. Duterte arises, for the most part, out of assumption layered on top of hearsay and follows a repetitive pattern which would, as a rule, entail the same mechanism of attribution. Namely, a hitman witness for the prosecution would state that his handler said that clearance came from, and I quote, above. But what does the word above mean? It means an unnamed superior and nothing more. The mode of liability imputed to Mr. Duterte, namely indirect perpetration, requires the prosecution to establish a stable chain of command through which the common enterprise filtered. If there indeed existed a structured approval process, as the prosecution alleges, one would expect operational consistency, not variability. The incidents contained in count 1 are also marked by internal inconsistencies which cannot be reconciled and which are indicative of the fragility of the prosecution's overall case. Incident number 1, for example, is based on the evidence of two witnesses who contradict each other on fundamental and materially crucial issues. Let me explain in more detail. P26, who presents himself as a participant, claims that Mr. Duterte telephoned a redacted third party to order the operation and was told that it was the mayor on the phone. Was told that the mayor was on the phone. Pure hearsay. The prosecution seeks to reinforce this through P2. Yet P2 was not present at the time. He was inactive for reasons I can't mention, and relies entirely on what he heard from the redacted third party and another individual at a later date. P2's account is therefore pure, unadulterated hearsay. More significantly, it diverges from P26's version on fundamental points. The year of the incident, 2014 and not 2013. The number of victims, 2 rather than 3. The identity of the perpetrators. The channel through which alleged clearance was conveyed, via driver and bodyguard, to a different DDS member rather than through redacted. And if that is not enough, the method of killing, strangulation rather than stabbing, these aren't minor inconsistencies. They concern the core factual matrix. If the pre-trial chamber is unable to determine even these basic circumstances which establish opportunity, method,
ayan po, pinutol po mga kaibigan. Nakita nyo guys, Sumenyas po. Kitang-kita naman natin, Sumenyas, di ba? Sino po nakakapansin? Sumenyas po si Blandy. Kumbaga, humaba yung nguso niya, ginanon niya, tapos biglang kinat. Di ba? Kita nyo, di ba? Sino pong nakapansin mga kaibigan? Bukas po, i-edit po natin, kunin natin yung nguso niya. Kitang-kita po mga kaibigan na talagang ngumunguso po siya guys. Ibig sabihin, huminto na. Itigil mo na, parang ganon. Kaya biglang pinutol. Ngayon, huling-huli siya, di ba? Meron pong mga part guys, siguro mga sensitive part, na talaga pala pinapahinto niya. Yung mga dating mga nakaraang mga naka-cut off, hindi po siya nakita eh. Ngayon nahuli siya eh. 'Di ba? Huling-huli po siya mga kaibigan. Sino po nakapansin diyan sa ating mga suki? 'Di ba? Kita nyo, 'di ba? Kita nyo naman? Ibig sabihin, siguro po ayon po sa ating ayon po sa aking pagsusuri guys, kasi nakita ko talaga yung uso niya gumanon siya ginanon niya yung sound siguro, yung kung sino man yung nasa audio nila or kung sino yung huminto, pinahinto niya, ayan huminto di ba? Di ba napansin niyo? Sino nakapansin? Hindi kasi natin pwedeng i-rewind pero i-rewind natin yan mamaya, no? I-edit natin, tingnan natin kung makuha ba natin yung pinakaano niya. Kitang-kita po talagang pag-nguso niya, huminto. Booking! Si Blondie! Kanina pa siya no? Kanina pa siya ano yung mata niya, parang talagang, ewan ko ba? Parang galit na galit siya na ewan. Hindi ko maintindihan yung facial expression niya. Talaga hindi siguro niya matanggap yung mga sinasabi ni Attorney Nicholas Kaufman kasi nga very striking medyo may konting lang po very emotional po yung sinabi ni Attorney Kaufman narinig niyo ba yun guys, yung talagang nakakaiyak pong pakinggan yung sinabi niya na kung makukulong man siya sabi niya ganon,
that, Your Honours, is conjecture, and we would submit that Article 61(7) of the Rome Statute does not permit charges to be confirmed on the basis of conjecture, on the basis of such a weak evidentiary basis. Now, since the prosecution made such a big deal out of incident 3 on Monday and screened the video of the hit job itself, if you recall, the one in a marketplace which was supposedly viewed with approval by our client, I would like to devote a few words to it. If your honours follow the transcript that accompanies this video viewing session, the prosecution fixated on the comments of Mr. Duterte telling the person operating the video not to zoom in.
Ayan, tinanggal na naman po dahil po mga kaibigan, talagang halatang-halata na po talaga guys. Ang pinag-uusapan naman nito yung kumuha sila ng video. Itong mga prosecution po, nagpalabas sila ng video guys na kumbaga parang pixelated po. Kasi nagsalita na yung may-ari. Hindi lang po natin ito na topic guys. Bukas na lang po, no? Pag-usapan po natin ito dahil naglikramo po yung may-ari ng video. Nakita ko yun sa isang wait lang Saan ko ba nakita yun? Hanapin po natin, no? Wait lang Kasi po mga kaibigan, ang nasa balita po, yung may-ari po ng video, ayan babasahin lang po natin Ito po nakalagay. Video owner, pumalag sa paggamit ng footage sa ICC hearings. So pumalag siya, yung may-ari ng video. Yung kung naalaala nyo, yung video na yun yung andun si Pangulong Duterte. May tinitingnan sila sa CCTV na di umano, ang sabi po ng mga prosecutors guys, pinapanood daw, ito ang sabi pinapanood daw ni Pangulong Duterte mga kaibigan kung paano pumaslang ang mga DDS. Yun yung pagkasabi nun. Oo. Pero mga kaibigan, nagsalita po ang owner. Ito na yung sinasabi ni ito na yung sinasabi ni Kaufman na pinutol nila. Ayan di ba? So, mga kaibigan, klarong-klaro po guys na yung pinapalabas nila na video sa ICC ay parang dinoktor po. Kasi nagsalita na yung owner Yung mismong owner po ng video So, ito kaya po itong si Attorney Nicholas Kaufman, sinasabi niya ngayon. Kaya pinutol. So, ngayon, talagang konfirmado na po guys, pag may mga sensitive po na mga topic na nai-involve po ang mga prosecutors, pinuputol nila. So, una sa lahat itong video na to mga kaibigan, kumbaga parang kasi to ang nagsabi niyan si Attorney Harry Roque. Nagtataka din po si Attorney Harry Roque guys kung paano po ito nakalabas. Kaya nga ang sabi po ni Attorney Harry Roque, may nagtaksil. Di ba? May nagtaksil sa kampo ni dating Pangulong Duterte. Kasi itong video na to guys, hindi to basta lalabas Kasi napaka-confidential po ito mga kaibigan. Pero biruin nyo, nakalabas at naidala pa sa ICC. Ang tanong, sino ang nagbigay nitong video? Di ba? Sino sa mga kampo ng Duterte po ang nagbigay nitong video na to? Kaya nga sabi ni Attorney Harry Roque, may nagtaksil. So ngayon, ito po ang tinatapik ngayon ni Attorney Nicholas Kaufman kasi lang pinutol na, wala na. Ibig sabihin, ayaw po nilang marinig yung sinasabi ni Attorney Nicholas Kaufman. Ayaw natin masaksihan na talagang ito pong ginagamit ng mga prosecutor ay hindi po sila nagpapaalam. Kung nagpapaalaman sila, meron ditong insight. Kaya di ba, nung nakarang araw, di ba may sinabi may insider? Oh. Sino ang insider? Tignan mo, ayaw ko lang kung babalik pa ito. Parang wala na eh. Wala nang oras eh. Ubos na yung oras nila, oh. Wala na. Ubos na yung oras nila. Binigyan lang siya ng mga 30 minutes eh. Wala na, sobra na siya sa 30 minutes si Attorney Nicholas Kaufman. Hindi na yata siya pinatuloy. Ewan ko lang, tutuloy pa ba yan? Di ba? So, talagang itong hearing na to, ako po, no, personally guys, to be honest sa inyo tingin ko dito guys, bias. Bias talaga. Kaya wag na kayo mag-expect. Alam na po natin kung anong magiging resulta nito. Ang nakakaiyak lang po mga kaibigan, na para ang very emotional po dito na part guys, yung sinabi ni Attorney Nicholas Kaufman kanina, na sabi niya na kung hindi man siya maano dito guys, kung guilty man siya, sabi ni Attorney Nicholas Kaufman, no, kung guilty man siya, no, kung ikukulong niyo siya, kung hindi siya makakalusot dito sa confirmation of charges, ang pakiusap po ni Attorney Nicholas Kaufman, sabi niya, please, sabi niya ganun, please release him with his interim release, with his interim, sabi niya ganun. Yun po yung pakiusap ni Attorney Nicholas Kaufman. Ibig sabihin guys, nagpapahiwatig po si Attorney Nicholas Kaufman na malamang sa malamang, kung may mangyari po dito guys, sana man lang pakawalan na po siya. Kahit mag-house arrest na lang po siya. O kaya, ibigay sa kanya yung interim release. Kung hindi ba siya mananalo dito, at least, laya na siya. Di ba? Laya siya, pero kailangan pa rin niyang dumalo sa mga hearing. Pero dapat, house arrest na siya. Hindi na siya dun sa detention center ng ICC. Yun yung nakakaiyak na part na sinabi ni Attorney Nicholas Kaufman. Ngayon, yung mga ibang part po, yung mga may sinasite po siya doon na mga nangyari dati na sana po mapagbigyan po or mahirap din kasi sabihin eh. Katulad niyan, tinamo, kinakat nga nila At nakita ko pa si Blandy. Talagang umuso siya, gumanon niya Ginanon niya guys. Biglang pinutol. Nung babanggitin na niya, nung sasabihin na po ni Nicholas Kaufman guys, gumanon kagad yung uso niya. Tapos tapos bumalik. Nung bumalik, may sinabi na naman si Nicholas Kaufman patungkol dun sa may-ari ng video. Pinutol na naman. Wala na talaga. Wala po tayo makukuha dito kasi pinuputol eh. Ano pa makukuha natin dito kung puputulin lang din pala nila? Ay kayo na lang mag-uusap dyan. Ano bang purpose ng live? Diba? Bakit nyo nila-live? Kung puputulin nyo na naman pala, edi wag nyo nang i-live. Diba? Kung puputulin lang nila, edi wag nyo nang i-live. Sus Maria Josep. Wala natin naman. Ewan ko lang kung babalik ka po yan. Kasi hindi naman sumobra na sa oras eh. Diba? Basta mga kaibigan, wag po tayo mag-isip ng negative. No? Basta prayers lang po. No? Prayers lang po guys. Kasi hindi natin alam. No? Hindi po natin alam. Basta ako, para sa akin po, gusto ko talaga guys, ma-vindicate po, no? Mabigyan po ng kalayaan si Pangulong Duterte. Ma-absuelto siya dito. Sino ba namang ayaw, di ba? Basta ang pinag-importante dyan, tuloy-tuloy lang po ang prayers natin kasi hindi pa naman tapos ang laban eh. Meron pa bukas. Meron pa tayong pinakahuling confirmation of charges. Pero sa tingin ko mukhang hindi na po babalik. Mukhang matatapos na po tayo guys dahil wala na sobra na sa oras. Ewan ko lang kung anong gagawin nila dito. So kayo po, no, kitang-kita nyo naman mga kaibigan kung gaano po sila kaano, di ba? Kung gaano po sila ka-bias. Oo, kasi nga kung siguro, meron sigurong, ewan ko lang kasi sinabi po ng ICC na mahigpit daw sila, baka siguro pinuputol dahil meron sigurong nasasabi si Attorney Nicholas Kaufman na bawal, kaya siguro pinuputol, no? Kasi mahigpit nga daw. Pero bakit naman sa prosecution walang putol? Pero pagdating sa defense may putol. Ano ba yan? Kahit nga si Attorney Panelo nagtaka bakit may putol. Nabitin lahat So wala na, hindi na po babalik yan kasi tinan mo anong oras na diba? So mga kaibigan, no? So hanggang dito na lang po tayo, guys. Magkita-kita po tayo bukas. Ang live po natin bukas, same time po, 1:30 PM. Tsaka abangan po natin ang pinakahuling yugto ng confirmation of charges. Sana po okay po bukas, no? Sana hindi po paputol-putol na naman. Bukas po mga kaibigan, ang pinakahuli na talaga, no? Ewan ko lang kung kailan po nila sasabihin ang pinaka-result or yung sinasabi nilang verdict. Di ba? Tingnan natin, guys. Kung talagang ano po mangyayari bukas, kung ewan ko lang kung baka bukas na po yung mga, baka siguro bukas na yung mga yung mga witness. Oo. Baka sila na po magsasalita bukas. Oo nga, yun nga yung tanong doon bakit sa mga prosecution walang putol, pero pagdating sa defense puro putol? Ano nangyari? Di ba? Talagang kitang-kita mo ang pagbabayas Tinan mo, hindi na bumalik tinan nyo hindi na bumalik. Pinutol na siya. Bastos, no? Bastos, no? Bastos ng bastos tong ICC na tong animil na to. Ayan, hindi na bumalik. Binastos nila si Attorney Nicholas Kaufman. Wala, hindi nila ginalang. Ewan ko, sa bagay, hindi naman talaga natin alam kung ano talagang patakaran dyan, no? Hindi natin alam, no? Kung sino po ang lumabag sa rules. Baka naman siguro may nilabag na batas itong si Attorney Nicholas Kaufman, kaya siya pinutol, no? Kasi hindi naman talaga natin alam kung ano ba talaga Bakit po siya pinutol, Wala namang paliwanag. Wala, Baka meron lang po tayo hindi narinig na rules and regulations ng ICC. Pero grabe, bakit bigla nilang puputulin in the middle of yung pag niya ng mga defense niya? Ayan na, bumalik na.
Judge Motok, thank you, Mr. Kaufman. We've come to the end of today's hearing, the third day. The hearing shall resume tomorrow at 10 a.m. Thank you, parties and participants. I thank our interpreters, the registry, the technical staff, and all those who have allowed this. Yes, Mr. Nichols?
To interrupt, Your Honors, just at the end of the day, but I wonder if we could go into private session for 1 minute before you leave the bench.
Oui, Mr. Nichols.
Yes, Mr. Nichols?
Wala na. Wala na po, guys. Pagbalik, wala na. Nag-end na. Pagbalik nila, wala na. Tapos na. Ano nangyari? Wala na, tapos na. Bukas na daw, alas 10. Giatay, mga buang, mga animal. Mga bastos kayo. Pinag-antay nyo kami, tapos wala. Sarap nyong kung pwede lang kayong kukulamin ko kayo Pinag-antay tayo ng matagal. Ilang oras 6 hours? Ha? 6 hours tayo nag-antay mga kaibigan, nag-abang, puro putol, puro cut off. Nahayop kayo. Hindi na kayo na demonyo, mga animal. Wala wala na. Pagbalik, wala na, tapos na. Bukas na lang daw. Kaya si Nicolas Kaufman ayaw magsalita, parang nagtampo no? Parang nagtampo, di ba? Nagsalita yung prosecution. Tinanong si Kaufman, ayaw magsalita. Hindi na siya nagsasalita kasi nga pinuputol nyo ako, hindi na ako magsasalita. Nagtampo siya, di ba? Na ano nyo? Nahalata nyo, guys? May konting tampo, no? Kasi lang, pinutol na naman. Every time po na magsasalita si Kaufman, pinuputol. Pinagsalita ang prosecution. Kita nyo yun, ha? Witness kayo, ha? Tinanong, ha? Nagtanong yung prosecution. Sabi niya, can we have a private session? Sabi niya gano'n, ha? Sabi ng prosecution. So sabi ni Blandy, yes. Kasi ano yun nung tinanong si Kaufman, hindi na siya sumagot. Pinutol na naman ang buang mga animal. Ewan ko sa inyo, ayaw ko na nga manood. Bukas hindi na ako manonood. Pagod na pagod tayo mag-aantay, tapos puputulin lang yung pinaka-importante na bagay na ewan ko sa inyo. Ito na siguro yung pinakamatinding kawalang hiyaan, no? Kawalang kwenta na hearing. Nag-request pa, ha? Nag-request pa ng private session, ha? Itong prosecution. Pero pagdating kay Kaufman, pinutol na naman. Giatay, nasayang lang yung pag-aantay nating animal to mga. Kaya tinan mo si Kaufman, ayaw na magsalita. Kasi useless Kung puputulin mo lang ako sa ere, anong sasabihin ng mga tao? Hoy, ano na? Nabitin kami. Anong nangyari? Pero anyway, tapos na po guys, no? So, bukas na lang po tayo ulit magkita-kita, no? Wala na po tayong magawa. That's it, no? Perhaps, no? I think, no? Meron po tayong meron siguro tayong nakaligtaan or meron siguro tayong hindi na nalalaman ng mga rules and regulations pertaining po dito sa hearing ngayon. Hindi ko lang talaga, baka siguro masyadong istrikto sila, no? Di ba? Malamang sa malamang mayroon siguro nilabag na rules. Kasi hindi naman basta-basta puputulin yan kung wala siyang nilabag Oo nga, lalay puyat na nga tayo, tapos ganun lang, puputulin lang ng mga hinayupak na itong mga animal. Mga jutang ginimis nyo. Gabaan sana kayo, mga hulihin kayo ng Russia. Hoy, Russia! President Putin, damputin mo na nga itong mga buang na sana damputin kayo, mga animal kayo. Opo, yun po. Tama po kayo, Omar Lapina. Bawal siguro yun. Bawal siguro yung off-topic, no? Kasi off-topic siya Sa tingin ko lang ito po'y assessment lamang, no? Bawal siguro yung off-topic, no? Kasi ang topic po dito, guys, is more of a crimes against humanity.
Judge Mochok, I was thanking the participants and parties, and then we had a few moments in private session, and now I would like to wish you a pleasant afternoon. We will see you all tomorrow, and once again I thank everyone, and this hearing is now adjourned. We will see one another tomorrow.
Nagpasalamat ang bruha. Nagpasalamat bang bruha? Buti bumalik. Bumalik pero nagpasalamat lang buang. Ha? Wala kaming pakialam sa pasalamat mo. Halatang halata, no? Klarong klaro. Akala siguro niya hindi ko mapapansin yung nguso niya. Oh, bukas i-edit ko yung nguso mo. Ipakita ko sa buong yung nguso mo. Buang blondie na tong animal. Sa muka ng mga buang Ay nako. So mga kaibigan, wala na po tayong magawa guys, no? Relax lang po tayo, no? Wala naman po sa atin 'yan, no? Ano lang naman 'yan. Baka siguro meron siguro silang mga rules. Pero hindi dapat nila ginagawa 'yan kasi pambabastos kasi 'yan 'Di ba? International sila tapos ganyan, no? Para silang hindi international criminal court, para silang local. Mas masahol pa sila sa local. Dapat pala hindi na lang international, no? Dapat palitan niyo yung pangalan nyo, hindi na international. Ano na lang kayo, palitan nyo ng local criminal court. Kakahiya kayo, mga buang kayo. Wala naman kayong ginawa, kundi nakaupo lang dyan. Pag ganun, puro ka lang nguso, wala. Magkano ba binabayad sa inyo dyan? Natatawa ako dito sa mga judges nito, puro lang nguso Yung isa naman, puro lang ng mata. Si Blondie naman, puro ganun-ganun sa buhok. Inaayos yung buhok, tapos yung mata niya pa yung fierce, very fierce yung niya, yung parang gumaganon pa yung mata niya. Yung nguso niya, humahaba, mabuang. Ewan ko sa inyo. Mahirap na po. Sabagay, ako, ayaw kong manaway, no? Puragaba ba? Puragaba na lang. So anyway guys, no? Once again, thank you very much po. Magpapasalamat din po tayo guys sa lahat po. At syempre guys, no? Palakpakan po natin once again. Bravo, Attorney Nicholas Kaufman. Magaling. Magaling po si Nicholas Kaufman, guys. So, bukas po tayo uli, no? Sa lahat po na subscribe sa amin, maraming salamat po. Sa mga hindi pa na-subscribe, please subscribe, comment, like. At pakihit yung notification bell para updated kayo sa aming mga bagong videos. ADF 2.0 po aming FB page. Follow, like, and share na mga videos. Ayun po. Hanggang dito na lang po tayo mga kaibigan. Magkita-kita po tayo bukas. Oo, nagsiga lang matang animal. Sabi nila Lane, nagsiga lang ang mata. Bulok, o nga, ICC bulok no? Kakaasar Walang kwenta. Tinagurian pa naman kayong ICC. Benita Galban, thank you very much. Mga kaibigan good night po, no? Gabi na. Yung pinaghihintay tayo sa wala, mga animal. Bye-bye guys. See you